Joseline, we are ready.
Ready? Okay.
Yes.
Okay, I'm going to call to order the Code Enforcement Special Magistrate hearings. It's a bit after 9 a.m., Wednesday, November 17th, 2021. The first order of business will be roll call.
Chief Code Enforcement Officer Joseline Ramirez.
Code Officer Teresa Malcolm.
Building Official Miguel Núñez.
Harry Hippler, Special Magistrate.
Administrative Assistant Nestle Cardona.
Code Clerk Mary Carey.
Okay, at this time, let me tell you all why you're here. I'm sure you know why you're here, but I'll tell you how these hearings are going to go. If you have any cellular phones, please go ahead and turn them off. I turned mine off, I hope. Let me double check because I don't want to violate my own rule. It's off, so please turn yours off. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that come before me, I would ask you to please show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor of or in opposition to a speaker. In other words, this is not a concert, it's a proceeding, okay, quasi-judicial proceeding. Hearings are conducted by special magistrate, the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special magistrate that's been assigned to these today in the every month hearings that the city has, the town has. I'm not a judge, but my role here is that to be of a fact finder to determine whether or not there are code violations in the cases that come before me and make those determinations. As a magistrate, my jurisdiction is limited. Since I'm not a judge, I have some discretion, but a limited amount of discretion, and the sole goal here is to determine if there are violations. Obviously, these hearings are open to the public. Anyone can attend. Ultimately, I'll go ahead and put everyone, or staff will put everyone under oath, including the code enforcement officer, after I conclude these this opening statement. In these hearings, formal rules of evidence relating to the witnesses and evidence does not apply. That means that hearsay evidence is admissible in these proceedings. If you have documents or any production of exhibits that you want me to consider, you'll let the city see them, and then I'll take a look at them as well. So if you think that'll help your case. The city may have documents on its behalf, and they'll do the same with you. Any document that is referenced, my opinion is that they should be put into the file since they're part of the public record. So if you have only one copy and you want another copy, make sure that you either take a photo of what you put into the record or the city puts into the record, or ask for a copy of that as well. But it needs to be put in the record because they are public hearings. Each party has a right to call witnesses on your behalf. The city does. You, as a respondent and alleged violator, have the right to do that, as well as to introduce exhibits and to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in a direct examination, to attempt to impeach any witnesses regardless of which party first called him to testify, and to rebut evidence against him. Unlike in court, where you have direct examination, cross-examination, and redirect, These hearings are in that regard casual, informal, and whether or not they would be or not, I would have them that way. So if you present, the city presents some testimony, you go, you want to say more, after the city says more, we can go back and forth for a reasonable amount of time, not, for hours, because that's not the purpose of these hearings. They're expedited procedures and hearings in which there's a resolution of whether or not there's a violation, and that's the purpose of them. After I listen to the evidence, it's my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special magistrate are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. And ultimately, if you are found to have violated the code provision you're charged with, you'll get a certain amount of time in which to comply before a per diem rate is assessed, whether it's $50 a day, $100 a day. For a first-time violation, it can be up to $250 a day. For a repeat violation, it can be up to $500 a day, depending on what you're charged with. Usually, it doesn't go up that high, and after I listen to what the city's position is and your position, if you can't agree, then I'll make a determination of what the per diem rate will be if it's not acceptable. I do have the right to modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. And as I just said, as I look at this script, I have the authority to assess and order payment of civil penalties for the amounts that I mentioned, to make sure that you comply, and if you don't comply, then the per diem rate will begin to accrue at the end of that time period. So you'll be given a certain amount of time to comply, whatever violation you're charged with. The burden of proof here is on the city to show by substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will find that there is a violation, the amount of the civil penalty, and administrative costs of the hearing is usually $100 if it's assessed, and usually it is assessed. But again, I'll listen to what the city has to say and you have to say. That's for these proceedings, because it does take time and funds to proceed with these matters. Is per Florida law and the statutes for code enforcement, if you do not agree with the final order that I enter, you have the right to appeal to the circuit court. It's a high burden to go to the circuit court in any of these proceedings, but that would be up to you. Used to be called, or still is, a writ of certiorari, but it is an appeal, and that's something, if you decide to appeal, that you would have to probably contact a lawyer, a private lawyer, to help you out with, if you decide to do that. As I said, if you are found guilty of the civil violation charged, you'll be assessed an administrative fee of $100. The city goes first. You, as a alleged violator, goes next, and each of you will present your testimony and evidence, and I'll consider what occurs in that regard. Okay. At this time, I'm gonna, if there are any minutes to adopt, I'll do that openly. I don't remember if I signed off on the prior ones, but I'll do that if I already haven't. I think I have. At this time, I'm going to go ahead and, there's also, this is adoption of agenda, deferrals, additions, or modifications. We can either do that now or just do that as the cases come along, whatever everyone's preference is. What do you prefer?
We can do it now.
Okay, go ahead.
I have one. I'm removing drawing case 5614.
Okay, just a little bit, speak more in the microphone.
You want me to repeat it?
Yeah, if you can. Usually I still have good hearing, but the day isn't over, but, go ahead. So,
I'm withdrawing case 5614 from the agenda.
okay. At this time, we'll begin the, I'm sorry, please.
Yes. Miguel Nunez, building official. I also have under the modifications, wording modifications of the agenda, case number 6390, which is item 7.4. They just recently came in compliance, so I would like to withdraw from the agenda. In addition to that, also case 6408, item number 7.11, also became in compliance
Great.
yesterday, so I would like to withdraw from the agenda.
Okay, we'll now swear in the witnesses. Why don't I have staff do that, if you'd be so kind, anyone? But you want to swear in the witnesses? No, okay, I'll go ahead and swear in the witnesses.
Excuse me.
Yeah.
The minutes, the meeting minutes are
Yes.
not adopted, the July?
Oh, yeah, I mentioned that already, yeah.
So they are adopted.
Yeah, they are.
Okay.
If they haven't been adopted yet? I'd asked that I thought that I'd adopted them or signed off on them, so why don't you double check?
Okay, now we are ready.
Okay, so they've been adopted, I believe, or not?
Yes.
Okay, I thought so, and I mentioned that, but that's okay. I'm going to go ahead and swear all witnesses are going to testify under oath. If you're going to testify, please raise your right hand. You don't have to get up if you can't or don't want to. Do you affirm you agree to tell the truth, the whole truth, and nothing but the truth? If you could please affirm.
Yes.
Okay, thank you so much. I don't think I've left anything out, so we'll go ahead and begin the proceedings. Whoever you want to call first. Thank you.
We'll call case 5943. And just for clarification, we'll begin with the attorneys present.
Yes. Good
Morning,
morning.
Magistrate Hippler.
And your name?
My name is Mike Smith. I'm appearing on behalf of my son in Lakeside Business Park.
Okay, great. Please, go ahead, proceed.
Well, let me present the case first, and
there you go.
then they'll go.
All right.
Chief Code Officer Jocelyn Ramirez, case 5943. Property owner I-95 Realty, Inc. Property address 2840 through 2886 South Park Road, Pembroke Park, Florida. A notice of violation was given on June 22, 2021 by regular mail. And a notice of hearing with a copy of the notice of violation was sent out by certified mail on October 28, 21 and posted to the property on November 4th, 2021. The violations were for exterior floor walls requires maintenance, i.e. pressure wash and paint. If changing the color, a permit must be obtained. If keeping the same color, no permit is required. Parking lot requires maintenance. Parking lot requires paving and restriping. Owner must obtain plans, permit, and inspections to do the paving. My recommendation for the property owner to comply is 45 days. If not, $100 per diem with $100 admin fee.
Okay, Mr. Smith, go ahead.
Thank you, Magistrate Hippler. I know I've spoken with Officer Ramirez as well as the city attorney, and unfortunately, we're in a position to have to agree that there has been non-compliance with the painting and the paving. As Your Honor knows, in these pandemic times, it's been very difficult for my son, who's with I-95 Realty, to not only collect rents, but to prevent tenants from leaving the property. So he's really got hit pretty difficult financially over the summer, and just before the summer, he's now starting to get back on his feet. As far as compliance with this, I've talked with the code enforcement officer as well as the city attorney, and my son has engaged in almost 20 different proposals for contracting and just the painting alone. The bids have been anywhere from the low 50s to over $250,000 just to paint the properties. Now, although the violation is for one single property and building, my son has decided to undergo a complete renovation of the entirety of the properties, all of the buildings there. So he has under contract with Hartzell Painting, and the anticipated commencement date of the painting will be this coming Monday. We're hoping, our proposal is to paint the buildings one at a time. They'll probably take a few weeks for each building, but certainly to start with the building that is the subject of the code violation, get that completed first. After the buildings are painted, then the renovation and the parking lot maintenance will commence. He's also spoken to different pavers and, painters and whatever they do with the parking lot, and they've indicated, all of them, that it would be best to have the painting of the buildings done so there's no runoff or spill off of the paint or any of the chemicals onto the pavement, so that the pavement can be done and the striping can be done. So it's anticipated as of Monday we begin painting the buildings. It'll take several weeks, or a few weeks anyway. I don't know what a few means, but I would think a couple weeks anyway to get to each building. Once that's completed, we'll do the paving. I'm hoping the court will agree to give us some time to get it done, and I understand the recommendation of 45 days, but I think that might be a little bit low for all the work that has to be done, number one, and also because we're entering into the holiday season. We're done with hopefully with the rainy season, and that was another problem with getting the painting done, because they didn't want to start with the hurricane season raining. So I would ask for a minimum of 60 days to try to seek compliance, and we certainly will keep the code enforcement officer apprised as to what's going on in the proceedings, as well as Your Honor and the city attorney.
Okay, all right,
60 days is fine.
okay, yeah, I think so, just 15 more, and we all know, nothing is on time. I didn't mean to say that, but it happens, unfortunately. So, all right, that's fine. I appreciate your comments and the like. And you come here representing your son, which is very nice of you to do that. Anyway, based on the testimony and the evidence that have been presented to me, there's substantial competent evidence to support the town's position. I'm going to go ahead and give you 60 days from today to comply with everything. It'll be $100 a day thereafter, and I'll go ahead and assess a $100 administrative cost fee for that purpose. Hopefully you'll be completed within the 60 days. If not, then you need to keep the code officer abreast as to the status, if anything. Hopefully you should be with the painting and whatever. If not, to see if a further extension of time. No guarantees, but if you're making reasonable progress, then certainly that would be an option, but just get it going.
We appreciate the comments,
That's
Judge, and
okay.
I've instructed my son to keep a diary at least a couple days a week as to the progress, so that we're in a position to at least memorialize for the officer what we're trying to get done and how it's progressing.
Great, that would be great, and that way you'll hopefully be able to avoid any fine. Otherwise, you'll wind up coming back to see me, and some
I
people
appreciate
like
seeing
me.
you, but
I know
not under
some
those
people like me,
circumstances.
some people don't. That's life. So okay, but get it done. All right, the city's really being fair. All
I
right?
understand, absolutely.
Okay, let me sign off on the order. You'll get a copy, and we'll go from there.
Thank you
Okay?
very much.
Thank you. Take care. All
Have a
right,
great
sure.
day, have a nice holiday, and stay safe.
Yes. There you go. Thank you.
Next case is 6186. Chief Code Officer Jocelyn Ramirez, case 6186, property owner Jeanette Vester, property address 2503 John P. Lyons Lane, Pembroke Park, Florida. A courtesy notice was given on September 9, 2020 by regular mail. A notice of violation was given on August 27, 2021 by certified mail. Notice of hearing with a copy of the notice of violation was also given on August 27, 2021 and posted to the property on September 7, 2021. A final order was given, but on September 15, 2021, but was vacated as well. So therefore, we're here today. A notice of formal hearing with a copy of the violation was sent out on October 12, 2021 by certified mail and posted to the property on November 4, 2021. Violations are for exterior maintenance, graffiti on rear of building facing Southwest 30th Avenue, exterior maintenance, building paint colors faded and/or stripped. Property owner will need to paint rear of building. Paint color will need to be approved by town planner prior to painting. And exterior maintenance of 4 walls, entire building, i.e. pressure wash, paint, treatment, repair, etc. My recommendation is to give the property owner 30 days, if not a per diem of $250 and a $100 admin fee.
Okay.
Good morning. My name is Martin Verster. I am the attorney for Jeanette Verster. I'm related to her, of course. I'm her stepson. I had communicated with the code enforcement officer before. This matter had come up before, and we tried to paint the wall. And within 2 days thereafter, it was re-graffitied. And I believe that the code enforcement recalls that incident. And so in order to get this job done, I was hoping to put cameras, lights, and a fence. I've been trying to obtain estimates for that. I obtained an estimate for that. The painting itself, I have already a contract to do the painting. But to do the work for lighting, fence, and cameras, that in and of itself, the quote is like $52,000. We have decided that right now the way to proceed is to go forward with just a fence. I have communicated and agreed with a fencing company to do the work. It's a 380-foot fence. They indicated that they need a little time because, number one, they need to do plans, and number two, the work has to be coordinated with a painting company because the fence needs to go right immediately after the painting has been done. As Mr. Smith, I believe it was Attorney Smith, just said, based upon the complexity of getting this done and the holidays, I would likewise request 60 days to get this done.
Okay. You say that the fence would be put up just after the painting. I mean, shouldn't the fence really, if you're having the graffiti problem, unfortunately, you know, and the camera security bit is a bit much to pay for, and you know, I don't know if you'll ever catch the police will ever catch the culprits to do that. So.
All right. Actually, a clarification is in order there. Your point is very well taken under normal circumstances. This property on the east side abuts the railroad track.
Oh,
And
okay.
the point is that there's an embankment going down. And for the fence to be put up, and I've spoken to the code enforcement officer, she spoke to the town planner to see if it was permitted to put that up, and apparently permission was obtained for that. But the special equipment is needed for it. They need one of these it's a high wall, it's 40 feet. So they need one of these carts to go there. I have 5 feet of property where the fence has to go. So in order for the painting to take place, equipment has to be there that is about 6 or 7 feet wide, and you always have a distance from the wall. We can't do the job with the fence up.
Okay, all right.
And so we have to do the paint first, and then I gather I have to get some security between the conclusion of the painting and the fence going up. But your point is well taken, but it's not possible under these circumstances.
What about rather than the security, I mean, would it be cheaper to get a guard there, a private guard? I have no idea. I'm just seeing if you can save some money doing that and expedite it, that's all.
But
it's up to you, all right? I like to be, broad-based to see, the purpose is to get this thing done. So anyway, go ahead. Your call in that department, but I just brought it up, so, all right. Any objection to 60 days or, no? Okay. All right. All right. Anything else?
no, that was it.
Okay.
Thank you.
No, thank you.
All right.
Based on the testimony of the Copeland's officer, there's substantial competent evidence to support the city's position. I'll give you 60 days from today to obtain compliance and get everything done. $250 per day thereafter and $100 administrative fee. All right, I'll sign the order. You'll get a copy momentarily. Thank you. Take care. Go ahead and call the next one. That way I'm.
That would be 5905. That's an attorney, yes.
There you go.
Can you repeat, please, the case number?
5905.
Good morning, Special Magistrate. This
Good
is
morning.
Mitchell Barrenechea on behalf of Hugo Sanchez.
Yes.
Yeah. This is the sign in.
Yeah,
Did
he
you
did.
sign in here?
My client signed, and then I advised whoever
okay.
was handling the signing sheet that I was here on behalf of my client, of Hugo Sanchez.
Okay.
They told me it was fine. That
All right.
Mitchell Barrenechea. Yeah. Barrenechea.
Code Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property owner Hugo Suarez. Site address is 3300 Pembroke Road, Lot 334, Pembroke Park, Florida 33021. Original notice of violation was delivered regular mail on June 4th, 2021. Notice of formal hearing with a copy of a notice of violation was certified mail on October 25th, 2021, and posted on November 3rd, 2021. Original notice of violations were for 3 mini split ACs installed without a permit. A gazebo was installed without a permit. A fence with trellis installed without a permit. Sheds, one with a washer inside without a permit. A roof over to the Florida room was added to the RV without a permit. Windows were added to the RV without a permit. Sliding glass doors, as well as stairs, were added to the permit. An awning was installed without a permit. The slabs for the AC mini splits were added without a permit. The slab poured underneath the shed was added without a permit. Also, they had a camera system that was installed without a permit and prohibited outside use of storage. My recommendation is 90 days with the $50 per diem plus a $100 admin fee.
All right, thank you very much. I was recently retained by Mr. Sanchez. I haven't been able to discuss with Officer Malcolm about this case, or I have not received any of the photos that I'm able now to observe. If it's okay with you, Special Magistrate, may I observe the photos before I respond?
Of course.
Thank
No,
you.
go ahead, please.
Oh, yeah, sure.
That might be easier for him.
Thank you. Thank you. So if I may explain a little bit of the background of what's
Sure.
going on here, Special Magistrate. My client is not the owner of this lot, of this property. I think it's common knowledge in this area that this property is owned by, I think it's Trinity Broadcast Florida, Inc., and that every lot is rented to each one of these mobile home owners. My client was under the impression that when he took over on this lot, whatever is being represented on this file, thank you, whatever is being represented on this file as a violation, without admitting that a violation exists, it was already there. I mean, it's nothing that my client went ahead and constructed, built, or placed into this property. Now, observing some of these photos, as to my first point is, it seems to me that many of the items on these violations that are being listed in this notice are violations that, as they relate to the land, to the lot itself. Some others are dealing with the RV. My client is not the owner. Again, I believe the owner of this lot, the owner of the lot, it is in a way an indispensable party to these proceedings, as this lot was rented on its as-is condition as of today, and all of this time it was my client's belief that all of these had to be taken care by the landlord in this case. I understand that potentially that's not going to be the case, that pursuant to potentially the lease agreement and the fact that he took the property with these conditions, he potentially might be responsible for whatever violation may exist in this matter. So my client would like to get the opportunity to discuss this with the landlord and determine whether this is something that they could comply with. My client works at less than $10 an hour. He's not able to pay these fines. He's not able to pay, I think, a point 14 of this notice. It states that a double permit fee has been assessed. If a double permit fee is assessed, it's going to make it pretty much impossible for my client to comply. He's not able to afford that. I'm working in this case pro bono. If it's coming into your mind, whether he cannot pay for these assessments or for these fees, but he's able to pay for an attorney. But second, in looking at some of these photos, it becomes clear to me that many, if not most, of these photos were taken by the officer inside the lot. I think some of those photos, they even go to the back of this lot, and I'm not sure if these photos were taken or if the officer entered this lot with some type of administrative search warrant or anything that would allow the officer to enter into these premises without a warrant. So in that regard, if I may have the opportunity to ask a question to the officer.
Sure, no, go ahead.
Officer Malcolm.
Mr. Hearing Officer, I'm going to enter my appearance on behalf of the town.
Sure.
As the town attorney, Melissa Anderson. If you, as an attorney, would like to discuss this case, we can.
Sure.
I can argue it in front of the hearing officer. I would note that the Florida statutes clearly spells out that, for whatever reason, and policy-wise, that park owners are not responsible for mobile home violations and vice versa. That's the way it's spelled out in the statutes. You might want to make sure that this is governed by the mobile home park statute. I'd look that up in the statutes if I were you, just to make sure. In terms of the illegal picture, or claim that these are illegal pictures, I mean, obviously she's taking them from a vantage point that you can clearly see from the lot line. So that is, it speaks for itself in terms of constitutional law. You're allowed to do that, stand at the lot line and take a picture. If he wants to question you about how they took these pictures, that's fine. But just for the record, in mobile home parks, the reason the mobile home park owner was not cited is under Florida statutes. They're not liable for the violations of mobile home owners.
You're absolutely right.
And that's what I said from the beginning, that
Okay,
might
let
be
me,
the
let me
case,
just ask, we have Trinity Broadcasting that owns the lot. The lot is rented by the RV owner. How difficult is it? These are RVs, they're not mobile homes, right?
It is my understanding that this is a mobile home, Your Honor.
Is it a mobile home or an RV? Okay,
In this case, this specific lot is an RV.
Okay. I was under the impression that Trinity Broadcasting or whatever, they used to be called something else, but I certainly know who they are, that if it's an RV, can't that be easily moved out of there?
I believe, Your Honor, and by the way, this is myself trying to make some of these arguments on behalf of my client.
No, you're doing a good job.
But my
Okay, go ahead.
client
That's all right.
wants to resolve this. Okay,
I know, I'm just asking, I'm not, I'm just asking some questions.
Yeah, so just to answer your question, Special Magistrate, some of the items that are listed here are basically attached to the land. Some others are easier to remove. For example, point 12 and 13, my client went ahead and removed the refrigerator and the security cameras. It was a security camera with a battery. There was not even wires. He's not sure why he's being cited for that. I believe the permits will require, the permits are required when there's any type of wiring attached to the cameras. But anyway, he's trying to get this resolved. So he removed the camera. He removed the refrigerator. I'm not sure if that can be seen here. But then as to the town's attorney's comment, I agree. I agree with you as to the what the law says about who is liable for a code violation, and I believe she's referring to Florida Statute 723.023. However, Florida Statute 723.022 also established that the mobile home park owner, the mobile home park owner's obligations, and subsection 1 states that the owner of the lot shall comply with all requirements of applicable building and housing and health codes. And I think those are the three items that are cited here in this notice. The reason that I'm bringing this up, Your Honor, is that because my client feels that he has done nothing wrong. He rented this property in its as-is condition, and the moment that the lot owner had possession of this lot without a tenant, the owner was under a responsibility to remedy any potential code violations. The moment that that the owner transferred the possession to my client, then basically transfer the problem to my client. So that's why I'm bringing this up, because it is my client's intent to talk to the landlord and see if they would help him out with this situation. He, like I said before, he's going through some hardship. He's earning less than the minimum wage, $10 an hour. He lives in this mobile home with his wife, who is disabled, and they're going through really rough times. I've never seen a notice of violation with that many violations listed. It is my client's impression as well that for some reason this is happening because he had an issue with the property manager, and then the property manager came to the town to make some type of complaint, probably to get back at him. But that's beyond the point. I know that we're here to determine whether a violation exists or not. So I responded to the town's attorney's comment, which I believe she's accurate in her assertions, but as well we have to take into consideration the other portion of the statute, which makes the mobile park owner also responsible. But if Your Honor believes that that's not persuasive, I'll just move to my next point, which is when we have a timestamp, but how did the officer obtain access to this lot, which is private property? My client, needless to say, has been commented by the town's attorney, has a fourth right amendment against any type of illegal search and seizure, and it is my impression from the photos that these photos were taken from inside the lot. And again, if there is anything that can be seen from outside the lot, I understand. I agree with the town's attorney. It's beyond the point as to whether there's a violation or not. But some of these photos, they go all the way to the back of the lot, where that cannot be seen from the streets. So as to any listed violation that has been listed here because there was access to the back of the lot, I would request Your Honor to strike or dismiss those violations. Lastly, in the alternative, if Your Honor believes that there are code violations, that these code violations are not the product of an illegal entry to my client's property, then I would ask to provide my client with 120 days so he would have the time to discuss this with the landlord and try to somehow get the funds to comply with what is being requested here, and to remove any type of double permit fee that would completely make it impossible for him to remedy any of the alleged violations here.
Okay, I'm well familiar with this statute, for its worth, and clearly the city attorney is absolutely correct that the owner of the park would only be liable for things that it put there involving the public welfare of the entire community, meaning the park there. The charges here have nothing to do with the park owner doing anything. In the olden days, it was what I would call strict liability before this statute was passed, where the owner of the land, no matter, would be liable. This is the first thing that's been carved out to take away from that strict liability of the owner of the property. You've heard it. You own the property, you take the good and the bad. Well,
yeah, and I agree. I'm
no,
not arguing that.
You're making good arguments, okay, and I've heard them before, some are first ones. But here the charges involved like putting up a gazebo without a permit by the RV or the mobile home owner, not the park owner, the washer, the roof without a permit, windows without permit, stairs, air conditioning without permit, camera without permit, outside use storage improper. Those are all issues as part of the statute that I think specifically fall within the statute, accepting, EXCEPTI, accepting responsibility by the park owner. So what the city did here is absolutely correct by not citing the park owner, but did cite the RV owner, the mobile home. Apparently, whatever it is, assuming it falls within the statute and appears to fall within the statute, because they probably not only lease out spaces for RVs, but also mobile homes on that property as well. And the statute has some criteria for that. So in that regard, and you made some really good arguments and the like, but be that as it may, those are violations that were produced or done by the owner of the the dwelling, whatever you want to call it. Also, if it is an RV, once again, RVs are easily movable, in my opinion, based on everything I know, if the people want to move. Now, if they don't want to move, then you have an issue of not moving, and then I don't know where that's going to take everybody, but I'm not prepared to decide that. So they can very easily cure all this, correct it, or leave, all right, and the like. As far as the warrant issue, you know, I don't really think that you have to get a warrant. First and foremost, let's see, my age here, Matt v. Ohio, I think before that, Katz v. U.S., about the exclusionary rule in the Fourth Amendment. Those things apply in the criminal context. Now, there are some old, very old cases with regard to OSHA that doesn't apply here, where there has to be consent given by someone that's bound by OSHA, which doesn't apply administratively, to go inside of a premise, business premise. That doesn't apply here. So I'm not aware of anything that says that a code enforcement officer can't go on an adjacent piece of property and take photos from that angle and the like. At least that's what my notion is. So based on that, whether or not consent was obtained or not, I don't think consent was necessary, but even if it was, I don't think it applies. The other thing is that the statute, and I've not seen any type of remedy in any cases that I'm familiar with that gives a magistrate the right to exclude something. In other words, a motion to suppress that's done in criminal cases, you know, where you know, a law enforcement officer gets a gun without a warrant, there's no exigent circumstances and the like. So there's really no remedy. Is it said in the olden days, assuming arguendo, everything you say is correct, there's still violations. We're talking about a non-criminal, nobody's going to jail type of proceeding. So I've heard that argument.
I'm sorry to interrupt. May
sure.
Just, as to the entry into the land, I just wanted to point out there's
please.
a specific Florida Attorney General advisory legal opinion which is on point. I can provide you with a copy, which basically answers that question, that code enforcement officers, being an arm of a local government, are subject to the Fourth Amendment, and they may not enter even though there are no criminal penalties for the alleged violations. They may not enter into a private lot or private land without a search warrant, or in this case, it would be an administrative warrant.
Yeah,
Um,
very familiar with that opinion. I just sent it out the other day to somebody. But if he wants to cross-examine the witness, she did not. She took all these pictures apparently because it was faster from outside the premises.
Right,
So it was conspicuous. It was open.
Right.
There is no
Plain view.
Yes,
Okay.
it was plain view.
If I may interject, I was there with Teresa Malcolm that day during the inspection. The property owner's wife was there. She invited us to go inside. We declined. We said what we came out to do is inspect the outside. So she was fine with it.
But I also want to ask, in the spirit of A, finding out what's really happening out there, and B, helping out somebody who, you know, is, according to him, he's doing this pro bono, and I don't have any doubt. You're claiming that the park did some of these improvements, not your client?
My client obtained these leasehold with the property as it is. He's surprised, and the reason that I'm talking about the park being responsible because he feels that he was lied by the park owners when they provided a lease agreement.
So did they have possession of this particular unit and they were controlling it before he rented it? The park owners, Trinity did?
The my client purchased the mobile home and rented the lot from the park owners. I'm not sure what's the time frame between when the prior tenant's lease ended and my client's lease initiated. So he's very surprised as to all of this because he purchased this as his own home in good faith. He entered into this lease agreement. And he feels that he was induced into entering into this lease agreement by the park owners' comments that everything is good. So,
And you know, honestly, the town is more than willing to talk to your client and to find out if in fact the park, when it was in possession or when it owned the property, is responsible for these violations. But I have to point out, it's my legal opinion that your client's still responsible for the violations because they took possession.
I agree.
So,
I agree with you.
So I would welcome a dialogue about what responsibility the park has after this hearing, but I think your client's still responsible for what's out
for
there.
purposes of these notices, I'm not saying that pursuant to Florida law, my client has no responsibility. I'm not saying that. What I'm saying is that my client will have to have a side conversation with the landlord and tell him, and have the conversation, you rented this lot to me with the representations that everything was good and up to code, and now I'm faced with these fines and with these violations, and I have to go through all of this work. I'm making $10 an hour. I'm 65 years old. My wife is disabled. I cannot handle this. I came over here to live in peace, but you basically rented me a list of 13 potential code violations here. So from a not code violation perspective, from a legal potential contract law perspective, what I'm saying is the park will have to potentially get involved here to assist him in resolving this. That's what I'm saying. That's why I bring the park because I believe that my client feels that he was induced to enter into this lot rental agreement under the representations that everything is good. There are no violations, and he does not speak English. He does not read English. He recently hired me to look into this. I explained him the gravity of the situation. And he's trying to comply. He did what he could. He moved the refrigerator. He removed the cameras. And to begin with, the cameras were there because someone stole some of his property from his backyard. So he wants to comply. He does not want to enter into an agreement or a fight with the town. That's not the case. he wants to comply, but at the same time, we would like to ask the town to give him some time so he can enter into these talks with the landlord, and either that or basically find someone to help him out to resolve, to get all of these permits. He doesn't know how to do that by himself. He doesn't have the funds. He will have to somehow find the funds to pay for all of these permit fees. He's an indigent for all, as a definition. If we look at this from a legal perspective, he makes less than the minimum hourly wage, and he wants to get this resolved, but if he can't pay for it, he basically will be out on the street.
Is this a month-to-month tenancy between the park owner and your client?
No, these are 12-month tenancies.
Well, okay, all right. Well, if there's a dispute between you and the park owner, tangentially, sometimes I will get involved in that, but in this instance, I will not, because if he bought it from whoever and it's his, he takes on these violations,
I agree.
Okay, no, it's what the law says. I didn't, maybe one day you'll be on an appellate court and you'll change the law, okay? Or the statutes, but not today. Nobody has any control over that, so. All right, so the 120 days, is that acceptable?
Yes.
Okay, all right.
I have no objection to the 121
So
days.
everyone got a little bit of a good argument by everyone.
And if
I'll put
I'm-
myself at the bottom of the list, but everyone else, the city attorney's great argument, council's great argument, and, wherever I wind up here. So, all right, I'll go ahead.
Blair, if I may interject, just for clarification, that property is a RV, Lake Trinity Estates, which is now owned by Trinity Broadcasting of South Florida, Inc. They have a variety of mobile homes as well as RVs. This particular lot is an RV, which they added the addition to it. So in regards to just pulling away and removing the RV, it's a little bit impossible. They would either have to get a permit to demo, which they could speak with Lucy or Jeffrey in the building department for more clarification on that. But you can't just pull away with the RV.
All right, I stand corrected. So this park, is it have a bunch of mobile homes on there?
Right, or
far
RVs.
more than 10, right?
Yes.
Okay,
And-
then the statute talks about 10 or more mobile homes. So you do fall within the statute, which is going to be, for whatever reason, the legislature with some of its lobbyists were able to say 10 or more mobile homes. There's testimony and evidence that it is more than that. So they fall within the statute, clearly. I knew they fell within it beforehand, but that conclusively demonstrates that. So what I'm going to do, I appreciate your argument, your zeal. If you're doing it pro bono, that's really great. Back in the 80s, I did a substantial amount of free legal work as well. So you should be commended for doing that. So anyway, if there's no other argument here, I'll go ahead and make my ruling, which is that based on the testimony, the evidence of the compliance officer and the argument of both counsel, who did a splendid job outlining the positions, I'm going to find that there's substantial competent evidence to support the town's position. The owner of the mobile home, Hugo Suarez, will be given 120 days in which to comply, or it'll be $50 a day thereafter, and there will be a $100 administrative fee. You may want to talk to Trinity Broadcasting. My understanding is they may be open to giving him a hand. I don't know if they will or if they won't, but that's between them, okay?
Absolutely.
But they are, so go ahead and do that.
Thank
And
you.
what I'll do is I'll enter the order.
Very
within-
much.
That's okay. That's all right. Right. Thank you. All right. Very good.
Excuse me, Special Magistrate.
Yes.
I forgot to ask you if you could, the double permit fee, could you mention in the order whether the double permit fee will be waived? I know it's mentioned in the notice, because again, if he has to pay a double fee for each permit,
That's something I can't really, all I can do is determine whether there's a violation. They may be willing to waive it, that's not up to me. So
I'm sorry, Magistrate. My name is Miguel Nunez. I'm the building official of the town of Pembroke Park. Double permit fees is mandated by State Statute 553 and the Florida Building Code. So you cannot be waived.
it cannot be waived.
No, sir. Not even under any circumstances. Thank you.
All right, thank you.
Okay, Mr. Magistrate, Miguel Nunez, I'm the building official.
Yes.
I'm going to be presenting case 6384. The property owner is Broward Roofing Supply of Hallandale, Inc. The address is 1751 South Park Road in Pembroke Park, Florida, 33009. This case is based on the recertification for the 40-year building safety inspection in accordance to Florida Building Code, Broward County Administrative Provisions, Section 110.15. The original requirement for this 40-year was done in 2018. There were no compliance at the time, so in 10/7, mail was for the formal hearing and notice of violation was sent to the property owner and all interested parties on record. For today's hearing, that gave him in addition, over 30 days for compliance. At this point in time, they're not being in compliance. Therefore, the town of Pembroke Park is looking for $100 administrative fee, $250 per day, and 15 days to be in compliance.
Okay. Your name and how are you related to the property?
Robert Van Snowball, and I own the property.
The owner?
Yes, sir.
Okay, great. What's up?
Dated November 2nd, 2021, and November 5th, 2021, I have certified stamped copies that the building is in compliance, but evidently, as smart as the engineers are, they did it on the wrong form that I found out this morning. These were delivered to me yesterday at 3 o'clock in the afternoon. I came in this morning and tried to get it done, and the gentleman informed me that they were on the wrong forms. He supplied me with the right forms, and I'd like you to let me get these guys to do it the right way.
Okay, is that have you seen the forms? You know what
No,
he's
I have
talking
not
about?
seen anything in there, and the problem to that is everything needs to be in compliance before that. Do you require repairs or not?
No, sir. But the engineers had those done since November 2nd and November 5th, and just got them to me yesterday, so I'm sure he can attest to that. There'd be no reason for me to lie about that, but that's the situation I'm in.
Yeah, these are the wrong form. I don't know, because when the communication was sent to the property owner, it was sent with the right form. Our right form is also in our website. So I can only say that they were not in compliance at this point in time.
Okay.
I'm not in a position right now to do a plan review for this particular plus. It needs to go into the electrical chief for the recertification of the electrical.
That's on the
instruction.
bottom one, sir. The bottom one's the electrical.
I understand that, sir.
Okay.
What I'm saying, I'm not in a position to do a formal plan review for you right now to make sure that everything is done.
I got
and
you.
that all the forms and all the letters are correct. So
The
that-
engineers were supplied with the packet that he gave me, and also the letter that they sent certified, so I have no idea why he
So-
didn't follow the rules.
I will suggest continue with the process.
Yeah, I
I'm
agree.
giving 15 days for him to comply. It appears that he's in compliance, but the process will need to maintain.
Okay, well, do you want this continued, or do you want me to enter a final order giving him the 15 days?
I would like for a final order
Okay.
to
Right.
be inconsistent with everybody else.
Right, okay, the only thing that'll do is that if you're in compliance, it sounds like it will be. What you may want to do is come back, and if you're in compliance, maybe ask the city to move to vacate the order. But I'm pretty much obligated to follow, which is a routine, not just against Broward Roofing Supply Inc., but against everybody. So that way, if they did the wrong form and you're in compliance, then this will be what's called moot. You have already complied. And you may ask them to, move to vacate it on the grounds that you are in compliance. But that's not something that I can decide right now, all right? Okay? All right,
I'll have
just-
to come back in front of you, basically, when this is all done.
No, not necessarily. If he says you're in compliance, then they may go ahead and have an agreement to vacate the final order down the road. But, if you're in compliance, there's not going to be a per diem, obviously.
Understood.
But try to stay on top of these things. Please, and also, there's just a ton of these out there now, billions of them. So nobody, these things happen. There are errors that are made. I'm the only one that's never made a mistake in my life. I'm kidding, of course. I've made plenty, okay? Everybody does. So just look at it that way. And as long as you're in compliance, nothing's going to happen.
Okay.
Stay on top of things,
Yeah,
please.
I'll give him this stuff today, and then hopefully he'll turn it right around for me.
Right, and make sure you continually communicate, email, call,
There was
whatever is
about 4 or
easy.
5 between emails that I sent him between then
Okay.
and now, and he
Well-
just drug his feet, so.
That's okay, well, whatever, anyway, so just go ahead and do that. So I'll go ahead and find that, at least as of today, there's a violation. You'll have 15 days, 250 per day. But if you're not in violation, this final order, probably, if you've complied, either they'll agree to render it moot, they'll have an order of compliance, or it'll be vacated. That'll be up to the city.
Okay. Yep.
All right, good luck to you.
Thanks.
Thanks for,
Sir,
Complying,
if you
yes.
want, take my business card from there, Jocelyn, if you'll be so kind. And just make sure that you engineer and let me know so I can move it along for you. That way, the goal is for you to reach the 15 days. Thank you, sir.
good luck, all right, take care. Thank you.
If you hold on a second, I will give you a copy.
Sir?
Sir, just, that way you'll have a case number, and you'll have a record, and please stay on top of things, please, okay?
Thank you. As Special Magistrate, my name is Miguel Nunez, building official. I'm going to be presenting case 63A6. The property owner is Pembroke Crown LLC. The site address is, my fault, 2565 South Park Lane. This is in violation of the recertification of the 40-year building safety inspection. The original notice was notified to the property owner in 2018. There was no compliance at that time. In October 7, 2021, a formal notice of hearing and a notice of violation was sent to the property owner. That given in excess of 30 days. So far, they're not be in compliance. They have submitted some report, but they're not in compliance at this point in time. Therefore, we're looking for, we believe this is a very life safety, so $100 administrative fee, $250 per day, and 15 days to be in compliance.
Are they here or not?
No, they're not here.
15 days for compliance?
Yes, sir.
Okay, based on the testimony, the evidence at compliance officer, there's substantial competent evidence to support the city's position. They'll have 15 days to comply, or $250 per day, and $100 administrative fee. Okay? Thank you.
Sir. Mr. Magistrate, Miguel Nunez, building official. Town of Pembroke Park. I'm going to be presenting case number 6388. The property owner is South Park Lane LLC. This is in, the property address is 2589 South Park Lane. This is in violation of the recertification of the 40-year safety inspection. Again, this was, the initial notification was in 2018. At this point in time, there's no compliance of the 40-year safety inspection. The date was sent in October 7, 2021 for today's hearing, and that leads for in excess of 30 days for compliance. At this point in time, they're not in compliance. Therefore, we are looking a final order for $100 administrative fee, $250 per day, and 15 days to be in compliance.
Based on the testimony of the evidence compliance officer, substantial competent evidence to support the city's position, they'll have 15 days to comply from today, or $250 per day and $100 administrative fee.
Thank you, sir. Mr. Magistrate Miguel Nunez, building official. I'm going to be presenting case 6392. The property order is ANO LLC. The property address is 1960 Southwest 30th Avenue. Sorry, I got the wrong folder. 30th Avenue. Pembroke Park, Florida 33009, sorry. This is in violation of the recertification of the 40-year building safety inspection, and the initial notification was in 2018. At this point in time, they are not in compliance. In October 7, 2021, the notice of violation and hearing was sent. That's over 30 days to be in compliance. I would also like to inform the magistrate that we received yesterday the 40-year recertification report. However, they were denied because they need to have repairs into the property. Repairs cannot be given additional times because the whole process needs to be completed within certain timelines in accordance to the Florida Building Code, Broward County Administrative Provision and Policy 0505. So therefore, I'm looking for a final order with $100 administrative fee, $250 per day if you're not in compliance within 15 days.
Your name?
Hi, Ryan Arcuri from F9 Properties, formerly ANO. We got the report over yesterday. We already have all the prices coming in, and we're getting the electrical contractor should be in by the end of the week to pull his permit, as well as the outside repairs.
Okay.
No problem with any of that.
All right. All right. Based on the testimony of the evidence compliance officer, substantial competent evidence to support the city's position, you'll be given 15 days to comply, $250 per day thereafter, and $100 administrative fee.
Miguel?
Thank
Mr. Arcuri has another case. Do you mind if we hear his other case?
No, please, he's here, might as well.
All right, give me a moment. I'm going to get Jeffrey.
Okay, great. So I went on this one, so which one is this? I take which, do you know what case number that was? 639. Okay, no problem, sorry. 6392.
Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park. Case number 4900 for A&O LLC, which is also Cabinets to Go, located at 1960 Southwest 30th Avenue, Bay B. This was a notice of violation written for the trailer sign that was up front, in front of the property, that was used for signage. The notice of violation was originally written on January 31st, 2020. It was sent to formal hearing on March 5th, 2020, and also on July 16, 2020. However, those meetings were canceled due to the pandemic. So the next formal hearing was April 13th, 2021. Which was found as guilty, and then a final order was issued as well on 4/13/2021. I'll present yours. Okay.
Mr. Hippler, Joseline Ramirez, Chief Code Enforcement Officer. This case is actually for a hearing to confirm fine. The reason why we're reiterating everything that happened is because I sent out an affidavit of non-compliance dated September 30, but I'd like to rectify that today. The inspection was actually done on October 4th. So I did send Mr. Arcudi a copy of that. The fine, there's a lien in place at the time. The fine stopped accruing on October 13, 2021. That's how the lien is placed as of the hearing on October 20, 2021. What I would like to do, based on Mr. Arcudi's email that he sent to me, he sent that the vehicle was removed on September 29, 2021. I would like to rectify the lien to reflect that the fine will stop accruing as of September 29, 2021. So it's more of rectifying the lien that is in place.
Okay.
Now, Mr. Arcudi is here. He would like to argue his case. So,
Okay, the cities, did you mention a amount, the corrected amount, in other words?
okay, I will.
But please, yeah.
The corrected amount is $7,050.
Order to, okay, all right, yes, sir. Your name, you could do for the
Morning
record.
again, Ryan Arcuri, F9 Properties, formerly A&O. Back in 2020, when we originally got this, we contacted Michael Miller as well as code enforcement in regards to it's a usable trailer that has correct license plates on it, up to date, which he responded back that he didn't agree with code compliance at that point, which we've sent the town attorney as well as code compliance, that this is just a trailer that is used from time to time, that's there, which we never heard back from code compliance after that, or Michael Miller. We had the couple hearings that were canceled. We got the final notice. We sent over this also to the town attorney and code compliance of the trailer being removed on May 13th of 2021. So it's been removed completely from the property, which is the day that it had to be in compliance anyways. So the trailer has not been there since. There's been a box truck that is used daily, which the last photos we got from Inspector Ramirez are of a box truck being at the property, not what was actually originally done for the violation.
The box truck was there. However, there was an expired tag at the time. So the
But that has-
violation is for using a trailer, a vehicle, as a permanent sign. That was the initial violation.
Yes,
Town
please.
attorney entering an appearance
Sure.
on behalf of the town. Violation is for a truck being used as a sign.
Right, okay.
That's the violation.
Not the trailer matter.
Correct.
Okay.
So that's a vital fact. Also, Mr. Curry sent us a photo last night, which it's not, in my opinion, admissible as evidence. I mean, it's.
I'm happy to get a signed affidavit saying that we
I-
got from the trucking company that it
First of all, I'm
covered.
talking.
Okay,
to
sorry.
One at a time.
Sorry about that.
Please. That's okay.
I wouldn't, I don't find it reliable evidence. It's curious that it's dated the day of the compliance and it was never produced until last night at the last minute. I thought that was very convenient. So anyway, that's the town's position.
Okay, he says May, you're saying sometime thereafter. After May, did somebody go on the property and see the violation?
Yes, the date of May, it was re-inspected and it was still there. At that time, the trailer being used for a sign was still there at the
Okay,
time.
what about sometime thereafter?
Thereafter, the case transferred to Officer Ramirez, and she checked it out from there.
And, okay, and you found that there was still the violation there. Okay. Also, the thing is that this is just a order to determine the amount of the violations. I would think that this should have been brought up at the final hearing or sometime beforehand. I know you're here with whatever evidence that you say you have, so what I'm going to do is I'm just going to let the amended supplemental order be entered, code enforcement lien, stated amount of $7,050 exist, that'll be amended. In the future, when you come back for a abatement, reduction of fine, if you want to do that, then, you might want to bring up these issues, and then maybe that can be hammered out as well. But, the thing is this, with all due respect, and, I'm a private lawyer, don't hold that against me, but this 11th hour, 11:59 p.m. type of bringing up, no, let me finish. To me, it's just really, I don't do it, okay? I wouldn't have the chutzpah, audacity to do it, but regardless, I'm not saying you're not doing what, your client or somebody may have given it to you then late. It's not your fault, whoever. So I'm going to leave this intact, and I'm going to enter the amended supplemental order. Your next course of business, if you want, there's compliance as of now, right? Or not?
Right.
Okay, so you're looking at $7,050, and you can come back for an abatement or reduction of fine in the future, and that would be your next course of business. At least that's my opinion. So I'm going to go ahead and sign off on the amended supplemental order at this time. All right?
Okay, is there photos of a tag that's expired, I guess, is my only question?
Yes.
I'm going to object at this point again. It's a hearing to confirm the fine. It's not an adjudication of the facts, which
Right.
have already been adjudicated.
Right, no, I agree with you. So this is not, there's actually case law out there, and the statute says that a hearing is not even required for these orders imposing liens. I forget exactly what they're called. I'd have to, look at it again, but there's, hearing is, but they put, the city and most cities do it anyway, put it on here. So Your next course of action is for
We'll be back.
reduction.
Don't worry.
Okay, all right,
Sir
take
Cody,
care.
you have the photos. I sent them to you.
Thank you.
Thank you. Good luck, okay.
Mr. Magistrate, Miguel Nunez, building official, Town of Pembroke Park. I'm going to be presenting case 6394. The property owner is B as in boy, K as in king, I-95 LLC. The property address is 2000 Southwest 30th Avenue, Pembroke Park, Florida 33009. This is in violation of the recertification of the 40-year building safety inspection. That the initial notification was sent in 2018, and at this point in time, there has not been any compliance. In October 7, 2021, a notice of formal hearing and a notice of NOV was sent for today's hearing. That's in excess of 30 days. And at this point in time, again, no compliance. Therefore, we're looking for a final order with $100 administrative fee, $250 per day on the violations for 15 days to be in compliance.
Based on the testimony, the evidence, the compliance officer, there's substantial competent evidence to support the city's position. I'm going to enter a final order granting the respondent 15 days to comply or $250 per day thereafter and $100 administrative fee. Thank you.
Sir. Miguel Nunez, building official, case number 6396. The property owner is Pembroke Park Warehouse Holding. Sorry. The property address is 3150 Pembroke Road in Pembroke Park, Florida 33009. This is in violation of the Florida Building Code, Section 110.15, about the recertification of the 40-year building safety inspection. The initial notification was sent in 2018, as of today, no compliance. On October 7, 2021, and notice of formal hearing and a notice of violation was sent to the property owner. And as of today, there's no action into their to be in compliance. Therefore, we're looking for a $100 administrative fee, $250 per day, and to be in compliance within 15 days.
Based on the testimony, the evidence, the compliance officer, there's substantial competent evidence to support the city's position. They'll have 15 days in which to comply, or $250 per day thereafter, and $100 cost assessment.
Miguel Nunez, building official, Town of Pembroke Park, case number 6402, Pembroke Park Warehouse. The property owner is Pembroke Park Warehouse Holding, Inc. And this is in violation of the Florida Building Code, Section 110.15, at the address of 3120 Southwest 19th Street, Pembroke Park, Florida 33009. This is in regards to the recertification of the 40-year building safety inspection. The initial notification was in 2018, and at this point in time, they are not in compliance. In October 8th, 2021, a notice of formal hearings and a notice of violation was sent, and they're still not in compliance. Therefore, we're looking for a final order, $100 administrative fee, $250 per day, 15 days to be in compliance.
Based on the testimony, the evidence, the compliance officer, there's substantial competent evidence to support the town's position. They'll have 15 days to comply, $250 per day, thereafter, and $100 cost fee. Thank you.
Miguel Nunez, building official, Town of Pembroke Park. This is case number 6404. And the address is 2727 Park Road, the property owner, I'm sorry, is 2727 Park Road LLC. And the site address is 2727 South Park Road, Pembroke Park, Florida 33009. This is in violation of the Florida Building Code Section 110.15 and the recertification of the Florida Building Code Safety Inspection. The initial notification of this property was sent in 2018. Therefore, and no compliance. Therefore, in October 8th, 2021, notice of formal hearing and notice of violation was sent, and as of today, there's been no compliance on this particular property. Therefore, we're looking for a final order for $100 administrative fee, $250 per day, and 15 days to be in compliance.
Testimony of the Code Compliance Officer, substantial competent evidence to support the city's position. They'll be given 15 days to comply, $250 per day thereafter, and a $100 cost fee. Thank you.
Sir?
Roll.
Yes, sir. I'd rather take care of all this right now.
No, I know.
Miguel Nunez, building official, case number 6406. The property owner is Villa Claribel and Villa Pablo and Villa Agustin C. The property address is 2517 South Park Road in Pembroke Park, Florida, 33009. This is in violation of the Florida Building Code Section 110.15 about the recertification of the Florida, the 40-year safety inspection. This was in 2018, the notification was sent, there was no compliance. And then in October 8, 2021, a notice of hearing and a notice of violation was sent to the property owner. And as of today, there's not been in compliance. I would like to set for the record, sir, that we sent by mistake a notice of compliance to them because this property is 2517 South Park Road. But we have also another violation in 2517 South Park Lane. So it was sent. It was also, next day, it was sent a letter, is on your file, removing that particular notice of compliance and explaining to them about the issue. I did speak with the property owner's son. I forgot the name, I apologize for that. I think it's Mr. Agustin. And at that time, it was explained to him, and this morning I had a conversation with Mr. Pablo Villa. I think he's present, and I explained again the situation to him. He knows that we're gonna be looking for a final order for $100 administrative fee, $250 per day, and 15 days to be in compliance.
Your name, please.
Oh, Pablo Villa.
Okay, and what's your position?
Okay, one of the owners.
Okay, you understand you have 15 days to comply?
Yes, sir, yeah.
Okay.
I just want to say something. The reason I didn't do anything before, in 2018, because I never got the letter. I knew something was going on because I got letters from people trying to do the inspection, but I never really got a letter. But that's besides the case now.
Take care of it and it'll go away.
No, we all taking care of it.
Good.
So
Okay,
15
great.
days, fair enough.
All right,
Thank you.
based on testimony of the compliance officers, just a second, don't leave. There's substantial competent evidence to support the town's position. You have 15 days to comply, $250 per day thereafter, a $100 cost assessment. Thank you.
Miguel Nunez, building official, Town of Pembroke Park, case number 6410. The property owner is J. Stephen Pembroke LLC. The address is 5301 Southwest 25th Court, Pembroke Park, Florida, 33009. This is in violation of the Florida Building Code Section 110.15 about the recertification of the 40-year building safety inspection. This point in time is not completed. And in October 8, 2021, the notice of formal hearing and the notice of violation was sent to the property owner. Obviously, that's in excess of 30 days. And still not in compliance. Therefore, we're looking for a final order for $100 administrative fee, $250 per day, and 15 days to be in compliance.
Yes, sir. Your name?
John Coma,
Yes.
partner. I don't have any comments. 15 days is perfect. I have the report completed. I just didn't realize we had to stamp all the pages. So if that's the only thing that's remaining, we'll take care of that and we'll get it finalized.
Okay, yeah, 15 days. Time runs fast, so please get it taken care of. And if you need to stamp the pages or whatever, get them stamped, or else you know what happens. Okay. Based on testimony, the Evanston Cove Lights offers you have 15 days in which to comply, or $250 per day thereafter, $100 cost assessment. Thank
Yes.
you. Good luck to you. All right.
Thank you, sir. And just to let you know, if my card is on the table, if you want it, just take it, and I'll be more than glad to assist you, so the 15 days we don't reach to that 15 days.
Yeah.
Thank you, sir.
Fuck, great.
Mr. Magistrate Miguel Nunez, Building Official, Town of Pembroke Park. I'm gonna be presenting the case 5074. The property owner is Park Lake Inc., and the address is, hold on a second, 3184 West Hallandale Beach Boulevard. This is an abatement of fine on this particular. At this point in time, I would like to abate 100% the fines. There was a miscommunication at the beginning, and between both parties, and because of that reason, I believe it's fair to do that action to the property owner. Therefore, I'm requesting the abatement to be in 100%.
Okay. I'll go ahead. That's all right. You want to make sure, or is it two? Right one, Park Lane.
Park Lake Inc.
Park Lane, okay, this is Park Lane.
Oh my God, so.
Is this vacating, abating, or?
I just.
Okay, that's all right, Park, up there.
Parley.
The first. No, that's okay. No, I'll just sign off and you'll do it. Oh, okay, so, if I'm gonna order of abate, the question I have is that there's a supplemental order, code enforcement lien. Do you want that signed as well? Or do we have to go that route?
I don't think we have to go that route because it hasn't been linked or anything like that, and it's full in compliance, so.
Okay, abated to zero.
Yeah.
Oh, abated to zero. Subject being paid within, not applicable, so it's abated to zero. All right. I'm not signing the, cross out this part. This had 5,800, so it's being abated to zero. It says that then in such events, the liens and fines shall revert back. So I need to re-sign it, or you want to do it? Abating it to zero, not applicable days of the hearing, and That's okay. I can sign off on it. You can, and I'm not going to sign a supplemental order because it's, you know, if I need to re-sign it, just let me know. Okay, thank you. All right.
Thank you, Mr. Magistrate. That will conclude all my cases.
Okay, thank you very, very much.
Code Officer Teresa Malcolm for Town of Pembroke Park, Florida, case 5927. Original notice of violation was mailed on June 15, 2021. Notice of formal hearing was certified mail on October 22nd, 2021. Posting date was November 3rd, 2021. Original notice of violations were for the following: a new walkway added to the side of mobile home without a permit, new AC installed without a permit. The Florida room was enclosed without a permit to verify the 2 patios if they were permitted. New windows were added to the mobile home without permits. A new door was added to the mobile home without permits. Confirm if the addition to the mobile home was permitted or not. Recommendation is to give the owners 90 days with a $50 per diem with a $100 admin fee. Property owner is here today.
Good morning, Mr. Magistrate.
Hi, how are you doing?
Good morning, officers.
Your names, please.
Yeah, my name is Marcia Shore. My friend in here is Ricardo Torres.
Okay, great, please.
Sir, I purchased this mobile home in April 14 to assist my friend who at that point needed to look for a property. He was already living in the park and he was looking for properties. When he found this property, he went to the association and he spoke to the ladies at the association and asked for any type of problems that the property may have. He was never informed that any violations existed. I spoke to both officers and they told me that what catch the eye of the city is the deck that was being under construction. When I purchased this property, number one, I did not know that this city existed. To our knowledge, the association was in charge of whatever was going on in the park. Based on that, we did not actually search for any type of city. Otherwise, we would have come here and find out if the property had any problems. My friend and I serve a Catholic church, and I know him since probably about more than 2 years. I know his integrity, I know his service. And we never actually thought that this pandemic was gonna come. The reason that I purchased the property from him is because he was going to go back to his country and sell his parents' property in there and pay me back. Unfortunately, he can't go back there. Consequently, because his job is very minimum, he does not make sufficient money to pay me so far up to today. He hasn't paid me anything yet. So I know the violations are very expensive. I know, and I understood based on the previous case, that unfortunately when we buy something, it is as it is. However, I am appealing to all of you to understand that this purchase was made on a good deed. I never asked him to pay me any interest. It was not for business. It was just to help a friend. And now, personally, I'm involved in this violations and any situations. He is willing to pay for what he owes me, and he's willing to work with the city to pay for the violations that he got involved in, which is the deck, not the previous violations. At this point, as I say, he have not paid me anything yet. And I'm just waiting for him to get any type of income so he can at least pay for half of what I used to buy the property. So, as I repeat, my situation, I do not want to regret doing a good deed, because I believe anyone who can do it for somebody else should do it, but not with these consequences of the law. Now,
The violations is a deck without a permit, is that it, or a bunch more?
The AC that was installed without a permit.
Okay.
Florida room was enclosed without a permit. Windows, new door was added without a permit.
which all that happened, not even previously to the couple that I purchased the property from, which they don't live in here anymore. They retired and they went to Dominican Republic, so I cannot even go after them. And according to my neighbor next door, the Florida room, which is the doors and the windows, they say that the guy that's not living here in Florida doesn't come because they are Canadians. He estimates that that addition was done like 17 years ago.
Okay,
I know we are responsible for the deck. And even myself, even though I never purchased a property for me to live in there, I can be responsible for that. I can take responsibility for that. But I do appeal to, as I said before, to all of you, please do not penalize a good deed. Don't do that.
okay, ma'am, look, here's what I'm required to do.
Uh-huh.
And this may turn out for you to be somewhat of a mini nightmare, but ultimately, when you buy a piece of property, you take the benefits and the burdens, whether the violations were done 17 years ago or, the deck. What you're going to need to do is comply with these violations in a certain amount of time, and it's going to cost you some money, but that's life, okay, if you want to continue to live there, and I'm sure you do and will. But once there's compliance, you can come back and ask for a reduction of any fine that accrued. But there are violations, and as a special magistrate, and I made it clear, I'm not a judge. I can't just wave a magic wand and say, you're okay with what happened, but everybody else isn't okay. I mean, the reason for code violations to have some uniformity. When I say uniformity, it's consistency, that everybody is supposed to comply, not just some, you're probably an innocent person with everything but the deck that you say you put up. So, but you're going to need to comply. The city's willing to give you 90 days. If you need more time, they may be willing to give you more time down the road. But I just think it's important for there to be a final order, because it's based on the evidence. So, move quickly, expeditiously, don't drag your feet, get it taken care of. It can't be that difficult to get an air conditioning matter involved with a permit after the fact, okay? Same with the Florida room, that's another story. When you start adding rooms to a mobile home or whatever, that's more of a problem, but that's something you're going to have to deal with. You need to get permits, so my hands are tied. So what I'm gonna do is, based on the testimony and the evidence that's been supplied to me, there is substantial competent evidence to find the violations here. You'll have 90 days in which to comply, or $50 a day thereafter. And the administrative fee, I know the order says 100, but I can cross that out and go, you said $50 administrative fee?
No, the $100 admin fees.
Okay, I took it down wrong. Okay, that's what I was,
Ms. Shirt, do you need more time than 90 days?
Yes, ma'am.
Would 120 days, 4 months?
Well, I myself gave him 90 days to try to pay me something. So if we can double that 90 days, so he can comply something with me, and then he can start complying with the city, I do appeal to that. Not only because I understand that he's not working every single day as I do, but at least also because he did actually went to the association. He did actually ask the association to give him information about the property, and the association never told him that anything was in trouble.
Okay. Also, okay, no have nothing in the property, I'm not sure nothing, you have any violation. The violation is because 10, 15 years ago, and no one inspected the house. I'm assuming, that the property is in the right condition, but later, okay, you check it out for the deck, big surprise. And I asked him
Your
for
name for the record?
And I asked him for the architect to.
His name is Mr. Ricardo Torres.
Ricardo Torres, and they asked him for the architect for the living room, okay, donde we have the window in, and the architect cost me, $35,000 for making it, because it's include the roof, the electric, everything. It's more what it cost the property. It's I don't know. I check it out with the city. I check it out with the association. Everything is okay. But after that, big surprise. What I can do? I have to pay more really when it costs the property, in violation. Because no, it's really the violation I pay for you. It's the violation I pay for the city. It's the violation, I have to pay for the architect, for the contractor, to make everything in the right way. The AC, no, it's the cost only the change the AC. It's the maybe change everything. It cost me maybe $760. That is the point. I see soccer. No, it's really our fault, and I really appreciate it. What he did for me. But at that point, the property cost $35,000, and I have to pay maybe $80,000. For the complete everything. It's, I don't have the money for pay that. I make the $10 an hour. And really, you give me 90 days, 120 days. Well, I can't do something. I have to pay her, but it's impossible for me, make the $100,000 in a year, for pay everything. It's impossible.
Okay, so you're telling me that you came to the city before purchasing the home, and the city told you that there was no records?
I asked you, remember? They say, the property had a violation before, I say, the property not had any violation before you inspect it. Because the property, the property not have any violation, because the owner kept serving the me, they cannot have any violation. The association, they say cannot have any violation. The violation is starting after you inspect the property. When you inspect the property, it's big surprise. Many things can do in the property without the permits. I asked it to the neighbor, and the neighbor say, they make it around 18 years ago that.
I understand, but this is the first time you and I have met, so you and I haven't met before. So maybe you met with a different officer, maybe?
Yeah, I asked him different officers.
Okay.
But if they check it out, it don't have any violation. No have violation. It show the square, any violation. The minute when you inspect it, I'm sorry, my English is really maybe poor.
You're doing fine.
The minute when you inspect it, you're surprised, you see that they make it the living room. You say they can put it the shirt in the back. You see many things not show in the original plan. Nobody know. And I asked it to the neighbor, and then I say, no, they make it around 15, 18 years ago.
Right, but they
And
did
the
that
code is
without permits. That's the thing.
But it's what I say. What I have to do, to buy some property, I have to go to the city. I did. I have to go to the association. They say everything is perfect. And now, when you inspect it, you see that no everything is perfect because you see a lot of things that they didn't. I don't think it's fair that.
Mr. Torres, what started this was the construction that was taking place the day Ms. Malcolm went and did the inspection. There was construction. You
The
put a
deck.
new,
The
You
deck.
put a new deck, and there was a door out there too. That was, I'm not sure what.
That is my fault.
Okay,
That is my
and
fault.
that is what gives us a red flag that construction is being active. And once that happens, the inspector has to inspect the whole house.
Exactly. But if you inspected the whole place over there, everybody had the
And you're
same
more
thing.
than welcome to
No,
go
if you
ahead
ins-
and report all those mobile homes that you see.
But that is the point. For change the window, the code can have the 15, 18 years ago with the same code to the now.
Okay, let's redirect this conversation to your case. Okay, anything else that you want to address other properties and everything, you can come to our office and we'll discuss it.
No,
But we're
don't say
talking
that.
about
I
your
would like
case
to know-
right now.
I would like to request, please, can give me really time because for fix every violation, to pay the architect, to make, I pay maybe in total, what I have to pay her, maybe $80,000.
Miss Malcolm is giving you 120 days. That is what she can give you. 120 days to comply.
Comply everything?
Yes?
I can do it.
Then you need to,
We have to
you need
destroy
to
the
make
house.
some progress.
I
You
have
need,
to destroy
in
the house.
120 days, you need to make some progress. Try to cancel out some things in your list.
Yeah, I'm gonna, I know, look,
I don't know, so you understand what is my point, because
okay, sir, you understand,
$80,000?
your English is excellent, actually, okay? I wish I could speak another language as well as you speak Spanish, really. It's good. The bottom line here is that when you buy a piece of property, I'll say it again, you take whatever violations occurred, and that's just the way it goes, okay? So she's gonna just have to, both of you or somebody's gonna have to correct these violations. If not, then there will be a per diem fine. You need to get it taken care of. What it costs really is not something that the city really ought to get involved in, whether it's a violation or not. So I'm gonna go ahead and, heard enough to know that, what my ruling is gonna be, and I'm not cutting anyone off, but I've heard enough, okay? Based on the testimony of evidence, the compliance officer, I'm going to find there's substantial competent evidence to support the city's position, and you'll have 120 days to comply, or $50 a day thereafter, and a $100 cost assessment in this case. You need to understand that if I were to say, well, it's okay, what you did, you didn't know about the air conditioning unit, the Florida room, the windows and the door, I'd have to do it for everybody. I can't just allow you and not allow other people to do it. It's got to be consistent. So make a plan and get it taken care of, all right? If you need more time after that, maybe the city will give you more time, maybe they won't. But you need to take care of it. That's really the bottom line here, okay?
Mr. Magistrate, can I request Mrs. Malcolm if she can please extend to 180 days?
I'm gonna go, even if she wants to, I'm going with 100. I was gonna insist on 90 days because I usually don't like to go out further than that. But I'll go with 120 days. So, if you need more time thereafter, that's between you and her, okay? It's 120 days. I have to, there's a lot of other cases waiting. This is really an easy case to decide for me. You're just gonna have to take care of it, that's all. And you'll find a way.
okay, I have to pay the $50 for each day or after the 120 days.
After the 120 days is $50 per day.
That is if he doesn't comply, or that is mandatory that
That is if he's not in compliance with everything.
with everything or with something?
With everything, after 120 days. So we're giving you 120 days to go ahead and correct the violation. So what you do is you progress, you keep in contact with myself and Jocelyn. And at some point, if you do need more time after, a little bit before that, let's say 115 days, you need more time, you'll reach out to myself or Jocelyn and let us know what's going on. And you can then request a hearing of extension for time, is what you do. after that. Okay?
You have to pay $50.
Hey, look, get a
Fines.
plan, get it taken care of. You know, that's the ruling. So the city was being very gracious. In other cases, I've seen them give the people only 60 days. Too bad after 60 days. You've got 120 days, get it taken care of, all right? Just have a plan. And maybe some of what is there you may have to get rid of with a permit.
Yeah, I'm really appreciative, you know, that you say, give me 120 days and later give me more time if needed. But what the meaning is, after the 120 days, I have to pay $50 a day.
If you haven't complied, if you've complied, you don't have to pay a dime.
I comply something?
No, it's
You have to stay in
everything.
communication.
Okay.
It's everything at 120 days. So let's say, like I said, 115 days, you realize that you're not in compliance with everything. You reach out to myself and Jocelyn, just let us know what's going on, and you can ask for an hearing of time after that. But you have to start doing something now.
Yeah, I agree.
Okay.
Just for clarification, because I see you're worried about the fine will continue to accrue until you reach compliance. Then we can stop the fine accruing once you reach full compliance. Then you can mitigate the fines. That's how the process works. It's not that you're going to pay us $50 per day. That's just going to continue to
That
accrue.
is what I want to clear, because if
Yes.
you know, you have to make a delay.
We understand.
Okay, thank you so much.
Get it done, make a plan, start going for it as of right now, okay? Do it, okay?
Thank you
All
so
right,
much.
good
I really
luck,
appreciate
take
what
care
you
of
do.
yourself, all right?
Okay, very important.
Sure.
Thank you so much.
The next case is case 4866. Chief Code Enforcement Officer Jocelyn Ramirez, case 4866. Property owner Warehouse 1800 LLC. Property address 2401 John P. Lyons Lane, Pembroke Park, Florida. Unit E 23 to 24. I'd like to clarify that this is a case that was opened by former officer James Tisdale, if you recall.
Yes, okay.
Okay, so this case has been open since October 4th, 2013, when the notice violation was issued for no business tax receipt.
Right.
At this current time, I am doing a hearing to confirm fine, because the file has been sitting there.
It's a small fine here, right? No, I'm kidding, it's 74,200, right?
Actually, fine is more than that.
Go ahead, yeah.
This case came into compliance in November 22nd, 2019, based on our business tax receipt department. The fine accrued for 2,204 days from November 9, 2013 to November 22nd, 2019 at a per diem of $50 per day. And that's a total of $110,200. There was a standard fine of $250 and an administrative fee of $100. The property owner did make a check payment of $100 for the admin fee. So the total remaining is $110,450.
Okay, the proposed order, this is Warehouse 1800 LLC Universal. Did you say 250 per day or 50 per day?
$50 per day.
50, okay, I thought you said two, I must be.
There was a standard fine of $250.
Okay, that's Right, that's the lump sum, the $250, and then the $50 a day. Okay, so what's remaining due and owing is $110,450.
Yes.
Right, okay, do you want to change that, and then, or I can go ahead and. Change it, it's, it's not 74 to no big deal.
Okay, the amount has to change.
450.
Didn't I give you that yesterday? The one that I left at your desk?
$110,450. Okay, or just yes, sir.
Your Majesty, my name is God Fowler, and I want to know how I can solve this matter.
Pardon me?
I want to know how I can solve this matter.
How you can solve it?
Yes, sir.
Well, do you have $110,450?
Oh, that sounds like I'm a very wealthy man. I wouldn't mind have that amount of money.
Yeah, really? Okay, what you need to do is, after the order that gets entered, this is just in order to approve the fine and the accrual, you'll need to file for what's a reduction or an abatement. And then there's paperwork for that. I think you'll have to, I don't know if it's $250 to file for that or $100, whatever it is with the city.
No, there's no charge. What you
Okay.
have to write is a letter requesting the special magistrate to mitigate the fines. And then once you submit that letter, you can send it to my email. I gave you my card yesterday. Then I will schedule a hearing to abate fine.
So you said I have to write a letter to you saying,
Well, requesting it to the special magistrate. A letter requesting to the special magistrate to mitigate the fines.
And you'll
Okay,
need
so
to
you could give
state
me some-
reasons, sir, you'll need to state legitimate, good reasons why it should be abated.
Okay.
Don't just say, I want to abate the fine, period, and sign it.
right,
A
no
bunch of
problem.
reasons, supporting documents, maybe there was a health reason involved, or I don't know. I'm not telling you what to say, that those things usually, whether they're legit or not, but you need to state reasons why it needs to be reduced, okay?
All right, no problem. Just give me something in writing so I can follow through.
Okay, well, you'll need to put it in writing. Email it, handwrite it, preferably email with attachments. You can use a computer, I'm sure. We all can by now.
We're living in that age, so we have to work with the time, no problem.
Okay, then that's what you need to do. And then, a magistrate, whether it's me or another person that sits here, after the city considers what you put in the request to decrease the fine, we'll just make a recommendation, and then I'll look at the recommendation, or the magistrate, whoever he or she is, will listen, and then maybe you'll get some relief, and maybe you won't.
I need that
Well,
relief.
I
I'm
know,
not in a
but-
position to accept that.
I
that
know,
amount of
but the
burden.
thing is that this went on for such a long time. I mean, it's really, we're not talking about some Lions thing to do some gigantic thing. I mean, this is the, what used to be called occupational license didn't have that. So what you need to do is do that. But right now, it's $110,450, okay? Copy of the order will be given to you.
No problem.
Thank you very much.
You're welcome. All the best.
Yes. Thank you.
Good luck. All right.
Next case is 6489. Chief Code Enforcement Officer Joseline Ramirez, case 6489, property owner Medina Land Holdings 12 LLC, tenant MTX Group 1 LLC. Property address 2570 South Park Road, Pembroke Park, Florida. The notice of violation was sent out on November 2nd, 2021 by certified mail. A notice of hearing with a copy of the violation was sent out by certified mail on November 2nd, 21, and posted to the property on November 4th, 2021. The violations are for the MTX Group 1 LLC continues to operate without a business tax receipt and inspections. Item 2, prohibited outdoor storage. Property has various construction equipment and materials stored in the open. Remove all construction materials or miscellaneous items. And multiple business trucks from NTX1 Group are obstructing town's right-of-way, and it is prohibited to obstruct town's right-of-way. At this current time, I have not seen the trucks obstruct the right-of-way, so that's in compliance as of now. As far as the prohibited outdoor storage, there's still items in the parking lot that are stored there. The property owner mentioned that they're willing to go ahead and get it cleaned up. And their business tax receipt is actually put on hold because they have to complete some work that they're doing. My recommendation is that they get everything resolved within 15 days, if not a $250 per diem with a $100 admin fee.
Your name?
Hi, I'm George Matamoros with MTX Group 1.
Okay, the gentleman in back of you, is he?
My name is Michael Arguez. I'm with Medina Land Holdings number 12. I'm with the property owner.
Okay, great.
The property manager.
Please.
And this is a repeat violation.
It is a repeat violation. Okay. Go ahead.
No, we're aware of the violations. We've actually met with Officer Ramirez, I believe it was last week, and we had a conversation about some things. Most of the items regarding the building permit have been approved and passed, but there is something still missing with the striping of the building, and that is a little bit back and forth between the zoning and building of what is it that they want us to do, because the problem that we're having right now is that when I address some of the building comments, it doesn't comply with zoning. When I address some of the zoning comments, it doesn't comply with building. So I'm kind of like in a circle here, unfortunately, because again, the state, which is partially something that keeps happening, it seems like it's something that happens, is we have an old building built in 1957 that we came into a lease agreement to operate our business out of. Of course, there were some things that we were unaware of, like the equipment and everything, which we are already making plans, as mentioned before. Hopefully very soon, in the next couple of weeks or less, hopefully, we'll be able to move it out, and that will be in compliance. But we entered into a lease agreement with the property that we did not know was going to be this challenging to bring up the code from 1957 to 2021. We're doing everything we can, but that has been the challenge. And right now, that is really the challenge. I submitted the drawings again for the striping, which is the only thing that's missing. But even though just 3 months, the problem that happened with the striping permit is it was null and void because of the time frame that it took to get it passed. So we resubmitted, and even though before it was passed by zoning, this next go around it was denied by zoning. So when I had a conversation yesterday with Ms. Siegel, the town planner, she asked me to do some things, and my concern is that now, while doing some things, it might affect now what the building wants. So I'm in a little bit of a, I just have to say, and I know we've had this conversation before, it's not a matter of getting the work done. The work done is easy. As a matter of fact, we as a contractor, we do striping. I mean, I could get this done in a day. The problem is getting it approved to comply with both of these entities, because it's very hard to take something that was that old and bring it to new. And I'm just gonna give out a very simple example. They want me to put a loading dock parking space where there's an overhang. But the problem is now I believe that will affect the building configuration in terms of life safety and everything. And I'm just, that's the problem that I'm having. The work itself, not an issue, and that's what's been happening throughout. So anyways, to come to full circle right now, I'm planning on resubmitting the drawings in today. My architect's already making that change, and I'll see what new comments will come up, because, you know, also to state this, to get the work done hasn't been an issue. Yeah, it's been a little hard in 2021 to get people to work and material chains and everything, but the problem has been getting the drawings approved. We've probably had to submit through building and the striping. I think we've gone through probably about 12 or 13 submissions just to try and get this done, and that's really been the holdup. So I just want to, I would like for you guys to really just understand that has really been the holdup, not so much the work. But regardless, we're submitting back today. Hopefully they approve it. If not, I have to go through another 5 or 6 roundabouts and figure out how to get it approved. And then the work, it should really take us a couple of days. To your point, because of that going back and forth between permits, I honestly will say, especially knowing that Thanksgiving is next week, that 15 days will probably not be enough. So I would like to ask you for a little longer time. Doesn't have to be tremendous, but at least 30 days, only because of that back and forth between the permits.
Okay, when you say 30 days, does that mean that you will have a business tax receipt at that time?
Well, just to give you timeframes, if I can get the buildings approved today, it'll take me 2 days to actually do the actual striping work. At that point,
And
I just
remove
have to,
everything from the parking lot?
well, yeah, so I told you that's happening within a couple weeks
Okay.
to get everything. So at that time, everything having to do with the building inspections has already been approved. I actually should be having a final once I get this striping inspected and approved. So at that point, I get a final building permit and everything, and I can submit for the local business tax. I'm not sure what's the time frame for that, but yes, I don't see a reason why within those 30 days I shouldn't have, because the
Your
only
other permits that you have pending, they've been completed?
everything has
Complete
been
inspections, it's
everything
just
is-
the parking
electrical,
lot?
mechanical, plumbing, structural, building, ADA, life safety, everything has been done. The only thing that why he hasn't given me a building final
Huh?
is because the striping, he considers it that he can't give me a building final until that. But in terms of the actual, if you
Can't
want,
give you a final for the other permits?
that's what he's saying, Mr.
Okay.
Nunez.
Okay, I'm
So-
just trying to understand.
So we've actually called for a final, and he checked everything, ADA, which was our last item. He checked everything, and I actually asked the building department to please schedule a final for the same day, and he said, you're done with what would be the building renovation, or whatever you want to call it, building 10 out portion of your permit, but I cannot give you a final until you get this striping thing finalized. Once I see that that's finalized and done, then I will give you a final for your building permit. So that's the reason why I don't have a building permit right now.
Okay.
And I asked him in that day, I said, hey, I feel these should be 2 separate items, but he believes it's one, and that's why we are here.
Okay, so 30 days is fine.
Okay, and $250 per day, okay, within 30. All right, based on the testimony, the evidence of compliance officer, I'm going to find there's substantial competent evidence to support the town's position. You have 30 days in which to comply with everything, or $250 per day thereafter. So get it done. That's the bottom line. Okay.
That goes for all the other violations? No?
I have to state those fines right now. Michael Argelis.
Yeah.
That's you.
George
George?
Matamoros. I did with her.
Yes. The second
Okay,
page.
got it. Okay. The next case is 5337. Chief Code Enforcement Officer Jocelyn Ramirez, case 5337, property owner Medina. Sorry, you guys changed your name. Medina Land Holdings 12 LLC, tenant MTX Group 1 LLC. Property address 2570 South Park Road, Pembroke Park, Florida. This matter is here today for a confirmation of fine. The confirmation of fine is the fine accrued for 122 days from July 18 to 21 to November 17, 21 at a per diem of $50. And the total accrued is $6,100 with an administration fee of $100. The total is $6,200.
Say, even though I'm not required to have testimony.
No, I think that just in the essence of the challenges that we've had with all of this, once we hopefully, within these 30 days that we can get all this resolved, I will most likely, go through the process of submitting a request to mitigate those fines, whatever that might be. But at this point, it's not really worth going through much when we're so close to getting it done.
Yeah, and I don't want to get into the merits because it's already been determined. Okay, I'll go ahead and confirm the fine, $6,200, and that's where we are for now. Okay. Thank you.
Okay, the next case is 5436. Chief Code Enforcement Officer Jocelyn Ramirez, case 5436. Property owner Medina Land Holdings 12 LLC, tenant MTX Group 1 LLC. Property address 2570 South Park Road, Pembroke Park, Florida. This matter is here for a confirmation of fine. The fine accrued for 122 days from July 18, 21 to November 17, 21 at a per diem of $50 with a $100 admin fee. The total is $6,200.
Same response?
Same.
Okay, I'll go ahead and confirm the fines for $6,200. You can come back for mitigation down the road, reduction.
Sure, I'd just like to, I'm not going to take much of your time, Ms. Jocelyn, but just a quick question. So the, normally, what is the time frame to pay this violation since it was, approved right now? And
You may pay the $100 admin fee at any time.
Okay.
Normally, it's within 30 days of the final order. However, the other fine, since you're going to mitigate it, you don't pay it after you mitigate it.
Right, no, that's what, I just want to make sure that, for example, let's say I have the 30 days to finish everything. So within those 30 days, that's when I will submit for the, well, let's say. I finish
Yeah,
it
when you're in
whatever
full
time.
compliance, that's when you can file a request.
Correct, I just want to make sure that there is not like a time frame where there's like, I don't know, liens or anything put on the property while I'm doing that mitigation.
This is
because
a lien now.
Okay.
So normally it takes 90 days for that. We're going to record the lien, and 90 days it can go up to foreclosure. But I don't think we're going to get to that point because you said that you're going to finish within 30 days. So once within 30 days you file for a request to mitigate the fine, we'll go back to the hearing officer and mitigate those fines.
Understood. Or pay the fines.
Or pay the fines, yeah.
Understood.
All right, that's it. Thank you. Take
Thank
care.
you so much.
Get it done, all right?
Wait 1 second, Nazzy gonna give you a copy of the final orders.
In a few minutes, if we could just take 5 minutes break, if that's okay.
No, if you need to take it.
It's the coffee. I've had a lot in the morning, so it's time.
Okay.
We'll
All
take
right.
5 minute
We're gonna
recess.
take. We're ready.
Yes. Case 5641. Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property owner is Barbara Miller. Property address is 5439 Southwest 41st Street in Pembroke Park, Florida, 33023. Original notice of violation was written on March 22nd, 2021. Affidavit of service was posted to the property on November 3rd, 2021. Certified mail on October 22nd, 2021. Original notice of violation was for AC that was installed without permits. Also for a new sliding glass door that was installed at the patio area that needed to be obtained with a permit and inspections. My recommendation, 60 days with a $50 per diem and a $100 admin fee. Ms.
My name is Dana Miller. I'm here on behalf of my mother, Barbara Miller.
Okay.
She said she didn't know that she needed a permit for an AC, for the AC unit. And she came in on Monday, this past Monday, to get the situation started. And she just asked for extension so she can get everything rectified.
So is 60 days enough time to?
That should be enough.
Okay.
There's also the sliding door matter as well. Know that?
The sliding door.
Sliding glass door at the patio.
There was something that she had on here with
Say $100 a day?
No, $50 per diem, $100 admin fee.
There you go, okay.
Ms. Miller is actually taking care of the sliding glass door. There was a permit that expired, so she's gonna go ahead and try to reinstate it.
Okay, we'll get it done. 60 days should be enough time. And
Thank
keep
you.
in touch with everyone to make sure that you're taking care of this, all right?
All right, thank you, sir.
Okay, thank you. Good luck to you. Based on testimony, based on the evidence, there's substantial competent evidence. 60 days, $50 a day, $100 administrative fee.
Everything else? It should be quick. Case 5717. Teresa Malcolm for Town of Pembroke Park, Florida. Properties site address is 5500 Southwest 32nd Street, Units 1 and 2, Pembroke Park, Florida. This is for Unit 1. Property owner is Alex Pierre Lewis. We're here today for confirmation of fines. The fines accrued for 90 days with the per diem of $150 per day. The fine total plus the admin fee is $13,600.
Your name, sir?
How you doing? My name is Alex Peerless. I'm the property owner.
Okay, yes, all right. This is a confirmation of the fine, so I'll let you're here, but you know nothing about the merits. So what's up?
I didn't know today was for the fines. I thought today was for the violations. I've done my best to keep in contact with Officer JOSELINE Ramirez. I've removed trash from the property. I've power pressured the property. I've even did a police report for trash that was being illegally dumped on the property. I've removed trash from the property. I've added dummy cameras to the property. I've taken care of pulling permits for water heater, electrical permits. I actually also contacted the office here to get a listing of your contractors who have already worked with the city in order to get building permit. The first batch of contractors that I contracted, that I got their information from the city when I did a public request, those contractors said they mostly only work on mobile home. Then I made a second public request, and those contractors said they only did fencing, but when they looked at my code violation, they said I needed a GC. Contacted the city again to get a list of the GCs. And through the GCs that I contracted, they gave me the runaround. One of them gave me a price quote that was insanely too high, way above my budget, that I could not afford. During the pandemic, I was trying to make renovations to the property, which is when the first violation came. I have been keeping up as much as I can to make all efforts in effort to make the property abide to the compliance with the property. I've been having financial issues due to COVID. I am a marketing executive. I don't own multiple properties. These are 2 properties that I own, and I'm trying to do my best to make go with the property. I now have a notice of commencement that I have contracted a new GC who said he would be here today with me. He didn't show up, and he said that he didn't get the letter notarized, but he said by the end of the week, he'll complete the form. Another thing that I also noted on the way here when I was talking to, my game plan is to take care of all these notices. Everything that I could personally do, I spoke to Officer Jocelyn. She told me, hey, there's trash on the property. Within 3 days, I went to the property, picked up the trash. Everything that I could physically do, I did. The water heater issue, I went back and forth with electrical and plumbing in order to take care of it. It took maybe 60 days, but that's what I was able to find: an electrical, find a plumber. So everything that I could physically do, I did. Now, regarding getting the GC, that's pretty expensive. And getting a GC to do the permit, I even asked for recommendation from when you guys came to inspect the water heater, and the inspector from the city said, hey, I can't make a recommendation. I'm not allowed to make a recommendation. When the electrical came to make an inspection of the water heater, I asked for a recommendation. Same thing. So I try to do everything that I can to take care of these violations and these notices. And now that I'm hearing about the amount of the fine, I thought I was here to go over the violations, which I'm trying to do. I already sent a wire to the contractor, and he's supposed to be taking care of the violation. Now, one more thing that I heard about today in the courtroom, and once more, I'm here because I want to take care of the violations.
Right. Good.
But I must say that when the officer entered my property, she entered my property without me being present, without me giving authorization. So she entered inside. It's not like she was outside of the property. She entered inside, and if you look through the pictures, a lot of these pictures are inside the property. Now, based on Amendment 4, I did not give any written consent, nor did anyone give her authority to enter the property or was able to give her authority to enter the property. And I'm not here to go into a legal matter of whether it was legal for her to enter the property or not. I'm here stating that I want to abide and I want to follow protocol.
If I may interject, Mr.
Sure.
Hippler, can you go to the next picture, Mary? So at that moment on April 6, 2021 at that date stamp on the pictures, Jocelyn and myself actually arrived at the property, and he had contractors working on the property doing renovations to the bathroom and interior of the Unit 1. The contractor that was doing the tiling and the flooring in his property is the one that gave us permission to enter. So we did have permission to enter. And the hearing was set for July 20th, 2021, but nobody appeared. So this is just a hearing for confirmation of fine. This isn't a hearing for mitigating at this time.
So, I mean, I'm pretty firm in my opinion that there's a statute. Is this homestead property or is this business property?
Homestead.
Homestead property? Okay. Not that it matters, but you want to comply. But again, I'm just really not that convinced that, if people throw out the Fourth Amendment in these administrative matters. Nobody, this is not a criminal case, and whether or not it applies or not, I mean, at least in this instance, someone that was lawfully on your property, let's assume for the sake of argument that the Fourth Amendment applies, which it does not, I don't believe.
It wasn't forced entry.
Yeah, but also a third party that's on your property legally
He hired.
can give consent to come onto your property. So, I mean, I would think that there would be case law to support that. I know look, you want to comply, and the best thing you can do for yourself is do that. Work toward getting compliance, and when you come back for a mitigation, reduction of fine, you can say you request a mitigation or abatement, reduction of fine. They're all the same in this city. Outline the reasons why, which is X, Y, and Z, that you complied with this. This took longer than it should, excessive costs and the like. But until there's compliance, you can't do that. You've got to get compliance before you can go back for mitigation. You're obviously astute, educated, and that's great, and you know your stuff. So just get it taken care of. So, I mean, I don't know really what else to say. So, in a confirmation, all I can do is confirm the fine that exists, and there still isn't, there's not compliance as of yet. So, I mean, when do you think you'll get it complied with?
So some of the items, well, thank you for that, but some of the items, like I said, I'm not a lawyer, I'm not here to debate legal
I know.
rules.
So you're doing fine. You may put lawyers out of business. You make a good argument. Go ahead.
Some of the fines that I have, some of the citations I've already taken care of.
Right, I know that. I understand. That's good.
The only citation that hasn't been taken care of is a citation with the GC contractor. He said he would be here this week. He hasn't. He sent me the letter. He said it needs to be notarized.
Right.
So I'm hoping that he's able to get it notarized and get it turned in before the end of the week. So I'm thinking 30 or 60 days. I'm not sure how long the process takes.
But get it done, and that's the bottom line. I can't really stay the accrual of the fines once there's a final order that's entered. It'll continue to accrue or accumulate until there's compliance.
So compliance is not until all the fines are done, not just some of them?
Right.
So I was under the impression that by communicating with Officer Ramirez and making progress on some of the violations, maybe not all of them, but some of the violations I was making on, I was on assumptions that the fines were put on stop or on pause.
Well, what that may do is at a mitigation hearing after there's compliance, show that you moved as quickly as you could, and maybe the contracting cost was excessive. Hopefully none of the ones that you've hired ran away with your money, God forbid, and didn't do what they're supposed to do. You sound like you have somebody that at least is going to do the job, and he has a history in Pembroke Park,
Well,
which is important, sort of, I mean, the city can't recommend anyone. They just give names as who have dealt with the city. That would be, I don't know if it'd be illegal or not. I just think it'd be improper. It would be a suggestion of impropriety and all that. So get it taken care of as quickly as you can. The city also mitigates the fine substantially once there's compliance. I mean, was it 85%, 80%, or 90%? Or
It depends.
It depends.
depends. Okay, it can go as high as that. So the quicker you work, and the more reasons you state in a request for abatement, the better off you'll be in trying to get it reduced substantially. All right? So just get
And
it.
what is the total right now?
13,600.
And what is the current violations that I still have to take care of?
I could give you my business card and we can meet outside of the hearing. We have to continue the case. It's confirmation of fines, okay?
Get it taken care of, okay? That's the bottom line. All right. Thank you. Good luck.
Hold on a second, so I give you a copy of your case.
Next case is 4985.
Can you repeat, please?
4985.
Chief Code Enforcement Officer Jocelyn Ramirez, case 4985. Property owner Garden Property 786 Inc. Property address 2950 Southwest 32nd Avenue, Pembroke Park, Florida. This matter is here for a hearing to confirm fine. The confirmation of fine is for 187 days that accrued from May 14, 21 to November 17, 21 at a per diem of $100. The total that accrued is $18,700 plus an $100 administration fee. So the total is $18,800.
Go ahead. Yes, ma'am.
Yes, hi, how are you?
But your name and the gentleman in back of
My
you.
name is Manara Amira, and I present my company, Violation Permitting Inc. and Petra Construction, or GC, and the owner.
Adil Sachwani, I'm the owner of the property.
Okay, your name again. You want?
Adil Sachwani.
Okay, great. Thank you. Go ahead. Just quickly and
We actually have two cases listed here, 4848.
Yes, we're going to go case by case.
Oh, okay. So let me start with the 4985. We were hired in June to address a couple of cases because when I looked at his account, they've been getting a lot of violations for the same issues but different cases numbers. So first, it took him a long time to get any GC to look at this because, as you know, around the pandemic and everything, we as a GC company, we don't. This is like pain. So we don't. So finally, when I saw the amount of cases just for bushes, and I said, let me try to help him first. So first, there's a lot of mail correspondence was sent to the address, which is, I know in SunBiz it's listed as his business, but he's not actually there. So by the time he got all of this mail, that was like, it took a while. There was multiple tenants there and a lot of issues that you guys listed, abandoned vehicle, all of this. He actually was working with Jeffrey, and I know Jeffrey. I've been working with Jeffrey for a while. I know how good with him to contact the owner. So he took care of all of this stuff, and I visited the site multiple times. When we started in June in timely manner, I was able to pull like 6 permits for the signs and it's, again, I need to repeat what one of the people were here. It's easy to do the work, and it's not easy to get permits from the city. I've been working with the city for a long time. It's
from
just-
no city, okay, it takes time for all the cities.
Yeah, but, with permitting, I mean, I
Right.
deal with all the cities. Some
Right.
cities is faster than others.
Yeah,
But
okay.
we got, I could list all the permits that were able to pull in a timely manner.
Okay, ma'am, look, here's the thing. This is a confirmation, and this is going to be better suited for what I said to the people for mitigation. Just get the job done, really,
We are,
please.
actually, I have photos that
Good.
all of the issues were
Okay.
done. The only thing I'm waiting on is Mr. Don, because he's the inspector and the electrical reviewer at the same time. It's taking me a while to get the electrical permit. Anything else was done and closed the permits, and I finalized all the inspections.
But I know, but I'm not really gonna get into that now. There's violations here.
And I'm working.
I know
nonstop
that's
to
great,
get it.
but that'll go when your client or you comes in for a mitigation or abatement or a reduction of fine, they're all the same. You outline the reasons why it took so long.
We will.
And the city is very flexible, very liberal about what it will do to reduce it. Now, there's no guarantee, they don't have to, but, they want to see right happen. Okay, so please, the best thing you can do is make sure that there's compliance. And so
that's what I'm working on.
okay, all right, so I'm gonna have to sign an order, a supplemental order in confirming the fine at this time, all right? Just for now, okay, get it taken care of.
Yes,
If you
we're
can,
at the last stage.
yeah.
And I think I have another case because we're here.
Okay, and that'll be for $18,800 in case number 4985.
Yes.
Great, thank you.
Next case is 4848. Chief Code Enforcement Officer Jocelyn Ramirez, case 4848, property owner Garden, property 786 Inc., tenant Family Grocery, property address 2950 Southwest 32nd Avenue, Pembroke Park, Florida. This matter is here to confirm a fine. The fine accrued for 116 days from June 18, 21 to October 12, 21. At a per diem of $250 per day, which accrue $29,000. In addition, a $100 admin fee. The total is $29,100. And this case is in compliance.
Okay, good.
No, but could I make a comment?
Yeah, quickly.
Quickly, very quickly.
And
I
then you're
promise.
gonna come back for a reduction.
I will.
Good, okay.
3 permits were pulled in timely manner, and I was waiting on the city to go out there and inspect an existing 2 signs that we had to pull 3 permits for. But why the fee is so high?
Because they continue to accrue until the city determines that there's compliance. Some people think that if they don't call the city and there's compliance, then it's going to be automatic. Something from one of those contraptions that flies around in the sky, oh, you've complied. That's not how it works. You have to tell the city, they have to go out and verify all that, and sometimes it sits, and it may take a few days for that to happen. So if you think it was excessive, when you do the mitigation or reduction
gonna
or
address
abatement,
that, definitely.
put all that in there, really,
But could I, because I have emails that we requested the final way before October, but Jeffrey wasn't able to go and inspect, so that's why till October. But I have a record here.
Like
that
the
was-
hearing officer said, you can bring all this. You already submitted
at
the letter to abate the fine. So I'm going to put this case in particular for an abatement, and that's when you can bring all those emails. However, according to the building department, all those permits were completed as of October 12th, 21.
Yeah, so I will bring the emails showing that we requested the
Okay.
inspection in June, because we were done and
Okay.
permit was issued. Okay.
Put everything in there so it's in
You
writing.
can send it to me also prior to the hearing.
Absolutely.
Last question, could I
Yeah, anyway, always send to those abatements, send to the code enforcement officer.
We are in
Because they're gonna make a recommendation, and, quite frankly, they're usually on all fours, all right, okay?
Will you guys inspect the property again
Yeah, we already did.
recently?
It was inspected on, let me see the photos. November 3rd, 2021.
November 3rd. Will you guys go inspect again?
Yeah, if you like.
Yeah, we have some photos. We wanted to send it to you guys.
Okay. All right.
Good luck to you, take care.
Thank you.
Okay.
That's Jeffrey. He's The next case is 4768. I believe that's Teresa's. Oh, no. That one's mine. It says here Yanidis Flores and Kimberly Matt. Did they put the wrong case? Do we have a Yanidis Flores or Kimberly Matt?
She signed it.
They signed in for you. Oh, okay.
And in the list, the 17, she signed it.
Okay.
In the 17.
I was worried I was going to be late.
What is that case, Mom?
I didn't know this took so long.
4772? 4768. Ah, 4768. Chief Code Enforcement Officer Jocelyn Ramirez, case 4768. Property owner, Hallandale Land Trust LLC. Property address 3195 West Hallandale Beach Boulevard. And as of today is West Hallandale Beach Boulevard because it's a vacant lot. The matters here for confirmation of fine as well as an abatement of fine. So we're going to go ahead and confirm the fine first. The total is $3,950. The property owner did pay the $100 admin fee. My recommendation is to abate the fine to reduce it by 90%, and that would amount to $395.
I'll take it.
I know, what a deal. If you had said no, I would have said, okay, $39.50. No, they're very fair, they
Very
really
fair.
are.
Very
Okay,
good.
and
Thank
you
you
worked,
very much.
you were diligent to get it done, and that's important too, so, you care.
We try.
So, of course, okay. And you can, you'll work out, it's the supplemental order, code enforcement, and then there's also an abatement here. That's the next one right here. Okay, I'll go ahead and abate. I'll confirm the fine at $39.50. The abatement is 90%, so it's $395. Okay,
And it has to be paid within 30 days unless
Can
you
I write
need.
that check now?
do it.
Do I get a discount?
You can. You may leave the payment with Jeffrey Lewis, but with checks, it takes us 10 days.
Okay.
The finance department takes them 10 days to confirm with us, and then we go ahead and submit. We mail out this affidavit of compliance.
How about a credit card? I mean, I'll just go over here.
We have to process this information,
Oh,
so.
so I can't do it today. I
Do the
You can-
payment.
You can do the payment.
Okay.
It's just,
You're going to take 10 days.
if you do credit card, I can send it the affidavit of compliance immediately.
Okay.
but we still have to enter this in the system, the abatement, so that 395 reflects.
Okay.
So,
Pay it today, get it over with.
Of course.
You know. I tell everyone. One of the harder ones should have been earlier. So.
I know.
No, I'm kidding about harder. Good.
oh, and with credit card is 3% tech fee.
So
FYI.
I'll just write a check.
Thank you for waiting and your courtesy as always. Take care.
If you hold on a second, I can give you a copy. Okay.
Double check 395. There you go. Thank you.
Case 5635. Code Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 5443 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owners Marsha Thompson. Original notice of violation was written on March 18, 2021. The formal hearing was certified mail on October 22nd, 2021, posted to the property on November 3rd, 2021. Original notice of violation was for a fence that was installed without a permit, as well as a canopy installed without a permit. Verify that it was original with the slab in 2005. Oh, sorry. My recommendation was $60 with the $50 per diem. 60 days with the $50 per diem.
Hi, my name is Marsha Thompson, and I purchased my property 10 years ago, and I purchased it as is. I was told in the beginning from the first association that there was a permit. Well, I left it alone. I didn't go to them and said, can I have the permit in hand? When you came after me, you said that, the deck was purchased, it was added without a permit. And I put the canopy myself because I thought, putting the canopy from Amazon, you wouldn't need a permit for that. I did not know. So they told me that I need an engineer to draw up the deck. I went all over looking for one. It was so much money, then they didn't want to deal with the city of Pembroke Park, whoever I found, because they said, you guys are so difficult. I'm just saying it like it is. Now, I got the permit. I came here 3 times at the building department. They said there's no permit. Nothing is in the system. Well, I went about it myself, and I went to the first owner, and I got the permit. Now I got the permit. I took it here. Now they're telling me that, okay, that I don't need that. I need a contractor because the fencing was installed after they put up the wooden deck. I did not know that. So they're saying that the first owner added the wooden deck around it after they pulled the permit. Now, that's a problem for me because we were found with a special assessment, which I'm still paying for $3,800, which recently added to, the place where I live. And it's so expensive because pulling permits here and pulling permits there and getting someone to draw up and all these things, it's really expensive. I'm not saying that I'm not going to do it because I don't want to tear anything down. I want to keep it the way it is. Now, I travel for job and I will be out of town for a month starting this Saturday. So it's going to be complicated for me. So I really need a little more time to get all of it. Well, I'll be away for a month, so I won't be back till the 20th of December. And I mean, if you could give me 90 days, because from December to February, I should be able to take care of it.
Is it the deck or is it the fence?
Well, originally it was the fence and the deck, but now she retrieved the permit for the deck itself. So now it would be for the fence as well as the canopy.
Okay.
Is what she needs to.
So that's even less than, so the deck is okay. So no, the deck would be the hardest thing, I would think.
But Your Honor, I'm just saying that if they kept telling me that there's no permit for a deck.
No. I'm suggesting in your favor.
Right.
You've
No,
got-
that's nice.
I know.
I love that.
So, but you're talking the deck. So it's the fence and the canopy. I mean, it can't be. And you're going to be out of town.
Right.
And you need 90. You say 90 days. Would you I'll throw a number out, and I'm going to defer to the code officer, since you seem to be wanting to comply and getting to the point. Is 120 days too long for this, or do you suggest 90? I'm going to defer it to you.
I have no objection to 120.
Okay, I mean, it's not that it's not serious, it's not dangerous, lest the canopy somehow falls down on a bunch of people. So, since you're gonna be out of town and, you fessed up and all that, 120 days, okay, so, all right, but get it done, because, if you come back in 120 days and say you need more time, they may say no, and I may say no.
Okay.
All right.
I understand. I thank you so much.
That's okay, all right, and if you can do it earlier, do it earlier. Don't,
I'll do it, yes.
don't play with the numbers and get it 119 days, all right? It's too dangerous to
Yeah.
do that, all right?
Okay, thank you so
So
much.
this way you'll have time, they won't have to come back, you'll look for an extension so within 120 days,
Okay.
$50. It's good that you found that old permit, so, because you just never know for sure. Okay.
Do my own investigation.
Maybe it'll
Thank
be
you
a
so
side
much.
job for you. You'll look for permits or
Yeah.
whatever. Well, I don't know about that. Anyway, based on testimony of the evidence compliance officer and the graciousness of the code enforcement officer, there's substantial competent evidence to support the town's position. You have 120 days from today, or $50 a day thereafter, and a $100 cost assessment. All right?
Thank you so much. I
Get it
appreciate
taken care of, all right? Please, all right? Thank you.
Wait one moment. Naz is going to give you a copy of your final order. Mr. Hippler, if you can swear everybody else in, because we had some people that came
Okay.
in.
All right, let me see the language that I use so I can not be too inconsistent. For those of you that came in, you raise your right hand, you don't need to get up. Do you affirm and swear to tell the truth, the whole truth, and nothing but the truth? If you could affirm, please. Thank you.
5186. Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 3196 West Hondo Beach Boulevard, Pembroke Park, Florida, 33009. Owners, Pembroke Park Lakes, Inc. Abatement of fine. So the fines accrued at a $50 per diem for 124 days. The $100 admin fee was recently paid, so the town's motion is to abate the fine by 90% for abatement of $600 due.
Kept it even, there you go. All right, what's your position?
My name is William Castellano. I am part owner and manager of Pembroke Park Lakes. I could agree to that 90% abatement.
All right, just for your own, if you would have disagreed, I would have disagreed with you, okay.
Yeah.
So abated to $600.
I appreciate you making this easy.
30 days. Keep in mind, if it's not paid within 30 days, it reverts back to the 6197, okay? And you don't want that to happen.
I do not.
Got it. Okay, give you a copy here.
Five, 630. Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 5451 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owner is Claire Renee. We're here today for an extension of time. My recommendation, give her 60 days with a per diem of $50.
Days and $50, okay.
Is 60 days good enough? Gives you ample time?
Yes, so far I've completed everything. On Monday, inspector came and he said that I had hinges that was 12 screws were required. My hinge had 11, so we have to look for it. And yeah, after that we're done. I already made the payments and everything, so yep, that should be enough. Thank you so much.
Based on testimony of the evidence compliance officer, I'm going to find there's substantial competent evidence to support the city's position. I'll give you 60 days in which to comply, or $50 per day thereafter, and $100 cost assessment. Yeah, this has Mr. Suarez's name on it. I'll just cross his name out and put mine. It's okay.
Clerical error. I'll have it corrected.
No big deal. I can write my, but just tell Mr. Rafael Suarez Rivas, I'm not crossing his name out because I don't like him. Okay? I don't want,
No
he
offense.
doesn't want to think that I signed his name for him.
Right.
Okay, you know, that's all.
Yes.
It doesn't matter. You can do it that way. Perfect, thank you. No big deal.
So the previous fees will not be accumulated?
It's
after the 60.
After the 60, on the 61st day.
Okay, thank you so much.
Yes, just wait 1 second on the side, and I'll still give you a copy of your final order.
Next case, 6189.
There you go.
Six, 189. Chief Code Enforcement Officer Jocelyn Ramirez, case 6189, property owner ESM 5401 LLC, property address 5401 Southwest 25th Court, Pembroke Park, Florida. This matter is here today for a hearing to extend time. My recommendation is to give the property owner 30 days. Mr. Mumon is here, if you'd like to state anything. And Mr. Hippler, can you swear in Mr.?
Oh, yeah,
Mhm.
okay. Let me get you to raise your right hand. Do you swear to tell the whole truth, nothing?
I don't hear nothing.
but
I
nothing
don't
but the
hear
truth?
well.
You affirm you'll tell the truth? Okay, you're affirming on the oath. Okay, thank you. Go ahead. They're saying 30 days and
30 days to comply. What he has remaining is to repair the dock station with permits, with building permits. So you just state your name for the record. State your name for the
My
record.
name is Roger Joseph Mimoun, manager of YESIM 5401 LLC at 5401 Southwest 25th Road,
Okay.
Pembroke Park.
okay, great. Okay, so it's within 30 days, or how much was it per day? Did you?
30 days, the per diem. The per diem is $250 since it's a repeat violation.
Right, okay. Right, and this is an extension of time, so it's going to be called an amended final order.
Right.
Okay, perfect. Okay, 30 days. Do it 30 days.
Can I approach? I don't hear you.
Pardon me?
Can you fix everything in 30 days?
In 30 days, hopefully, yes. I will do it, yeah.
Okay, all right. Right, based on, I'm going to grant the extension of time. You'll have 30 days from today to comply, or $250 per day thereafter. So, you hear me? Do you hear me?
Can I approach?
Do you hear me?
I don't hear you well.
Oh, okay, I'm sorry to hear that. What, you're gonna have 30 days from today to comply, or $250 a day thereafter.
$250 to pay?
After.
Have 30 days from
comply.
today to comply. If you don't comply within 30 days, it's $250 thereafter.
Okay.
Get it done, okay, please, please.
I wasn't here, that's why. I was away.
Okay,
Okay, I will do it.
please do it, okay? All right, good luck, thank you. That's
I will
okay.
give you a copy, so can you wait a minute so I give you the copy? Okay, thank you.
Thank you, good luck.
This is next.
Oh, you want me to do this? Oh, this is the other one that crossed out. That's okay, whatever. Sure, but at the microphone say it, because they won't be able to pick you up, okay? Go ahead.
I just want to say that all of you in this hearing, working here, are fantastic people. You are helping the people of.
Well, the staff does an outstanding job. I'm not sure about me, but they do a great job, okay? And they try. What they go through is really difficult, okay? Good luck. Flattery will get you everywhere. No, I'm kidding. There you go. I'll throw this away, that way we won't get confused.
We'll shred it, no worries.
Oh, you shred it? Oh,
Yeah, I did.
The old-fashioned way, I just.
Case 6313. Officer Teresa Malcolm for Town of Pembroke Park, Florida. Property site address is 3215 Southwest 52nd Avenue, Unit 84. Property owners is Holly Ridge Apartments, LLC, in care of Elon Property Management. Original notice of violation was on September 27, 2021. Notice of formal hearing was mailed out by certified mail on October 25th, 2021. Posting to the property on November 3rd, 2021. Original notice of violation was for a stop work order for the demolition of the interior in Unit 84s, including drywall framing, interior renovation started without a permit, including drywall replacement, new framing, and electrical and plumbing work. A double permit fee was assessed for all work that was done without permits. My recommendation, since this is their second offense, referencing case 5039, give them 30 days to become in compliance, and $2 per diem after that. Have
50?
250 per
That's
diem.
what I thought, okay.
And we have Mr. Peter Vey here, half of Holly Ridge.
Okay.
I'm an employee of
And the gentleman in the back of your colleague?
he's a contractor. that
Okay,
I've
well,
hired.
come on, don't say he's important, come on up.
Yeah, well, he didn't want to come up. I had to beg him to stand,
Well,
for God's
you
sake.
need to come on up, okay.
Hi, Orville Johnson, Brown Construction.
Great, thank you, go ahead. Yeah.
Okay, so really, I'm here to request an extension, and I'll explain why. 30 days probably won't be enough because of what's required. He's the main contractor applying for the building permit. I've already hired a plumber and electrician, applications here. They've been to the city and notified certain people, perhaps it was Jeffrey. So what we do have, what this case, not case, but what this permit's going to require is, once again, like the first offense, engineered drawings, sealed, the whole 9 yards. So, as we speak, those sealed papers are on someone's desk inside, I'm sorry, I can't tell you who, pending approval for what we're calling the first offense.
Okay, how many
If
days?
that gets approved, I can utilize all of those documents
Okay.
for his case, which
All
is this unit.
How many days are you requesting?
I'm hearing everyone talk about 90 and 120. I really believe I need that.
Well, everyone's not talking about 90, 120. I know that, Mr. Contractor, come on up. How many days? Come on.
Depending, once we get it approved, it's gonna need about 60 days, so sitting on somebody's desk, it's gonna be 90 to 120 days for us to get the work done.
Right.
Because we know some of the work will require us to now take down what was done and to get inspected, and then we gotta put it back to get re-inspected again. So that's some of the stuff we gotta get done. So on that side, it's gonna take a little bit of time. And we're waiting on the permits at this point.
Right. So, let me just add, if I may.
Sure.
Even though Officer Teresa mentioned the items that are wrong, actually, to be compliant, we have to do much more. You know what I mean? That's not listed.
Okay, what do you say? You know, you're asking for 90 or 120. 120 may be a bit much.
I can settle for 90 days.
Okay, all right. We'll give you 90 days. That way, you won't have to come back for an extension of time and go through this. Just get it done, all right?
Will do.
Nothing comes easy. It's not anyone's fault.
We have two matters to finish.
Right, okay, so based on the testimony as a compliance officer, substantial competent evidence supports the city's position. You'll have 90 days to comply, or it'll be $250 per day thereafter. So that's a whole heap of money thereafter. So get it taken care of, all right?
Thank you.
Thank you. Take care.
I did.
Thank you.
Next case, 6426. Chief Code Enforcement Officer Jocelyn Ramirez, case 6426. Property owner Gerald Anderson, property address 1708 Southwest 31st Avenue, Pembroke Park, Florida. Notice of violation was given on October 14, 2021 by certified mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on October 15, 21, posted to the property on November 4, 2021. The violations were for A and B recycling has an accumulation of scrap metals and hazardous materials causing spillover onto other businesses on town's right-of-way. Property owner is in violation of the certificate of occupancy. Business owners is using town's road and public parking area to unload and reload scrap metals and materials. Business owner is only allowed to operate within 1708 Southwest 31st Avenue property lines. Prohibited use of public parking area, public parking area to unload for business use. Property owner is using public parking to park his forklift for business use. Remove forklift from public parking area. Property owner has abandoned truck parked on Towns Road in front of property line. Remove abandoned vehicle and do not park on Towns Road for business use or for any purpose. Prohibited parking. Towns Road has to be clear. And this is a repeat violation, is a third offense. And my recommendation is to have the town's road cleared in 5 days, if not a $500 per diem with an admin fee of $100. The relating cases of the repeat violations are case 4400 and case 5523.
Okay. I vaguely recall that that you've been in violation numerous times, I think, in the past. So what's the story? What's going on? What's your position?
Well, my biggest issue is help. My biggest issue. Help is hard to find, as it is in the United States today, not just today, but for a little while now, more than a couple years. But my biggest issue is help. I have little help. I've hired 6 people this year. 1 died, 1 had a stroke, 1 got COVID. The COVID guy, he's in and out, in and out. I have new people, I don't know very much. Got to train them. Just a slow process. In regards to a vehicle, I don't know what you're referring to because I never stored a abandoned vehicle at my place. Never.
Abandoned vehicle is which is that truck right there on the photo, and there's an expired tag on it. That means that it's abandoned. When there's no, that's the terminology that the town code ordinance uses.
Which truck?
The grayish truck right there.
That truck is outside now.
Okay, sir, I've done multiple inspections. That truck has been there within the time that was given to comply. So if you're telling me now that that's a different story, you have not called for a reinspection.
Miss Romance, that's my truck. My tag
Okay,
is
it
good.
needs an updated tag.
No, ma'am.
And it cannot be parked there.
My tag is good. My tag is good to January of my birthday next year. So my tag is good.
Okay, you understand you can't be parked there.
I understand that part, but it's not a abandoned vehicle.
And do you see the picture of the tag, Mary?
I can bring you the registration. I have it outside.
No, the other truck.
But you know that's that.
I think that.
Here it is.
Wait,
Mary, go back.
lower down.
2022. My birthday is in January.
So you just have to remove it then. That's all you have to do. Because they cannot be stored there on Towns Row.
It's not stored, just parked.
It's parked, stored, whatever, because I see you have it there and you're putting items, you're loading your materials on it, and it's been there for a long time. I came up to you and told you you had to remove it. You did not remove it. It's been there. And you continue to use the town's role for business use. And I also told you, if you are not working with us, we can't work with you.
I don't work with you.
The city, I mean the
I
city.
don't work with the city. You represent the city.
Exactly.
You told me to clean my wall the last time I painted my wall.
That's a separate violation.
No, I'm just telling you, saying, I'm giving you.
Yeah, but you're not in
circumstances that
communication with me.
I'm
You are not
working
in communication with me because I have not received phone calls. Jocelyn, I got this done. Jocelyn, I fixed my fence. Jocelyn, come out.
when I was here last
Come out and check.
last case I
And
was
last
here, I
time,
mentioned that.
everything was debunked. Nothing was in compliance. Thereafter, there has been no re-inspections, nothing from you communicating to us, please come and look at my property. I got this fixed. There is no communication.
When I was here last time, the wall issue came up. I mentioned it right here. I painted the wall. I didn't just clean the wall.
Okay.
I painted the wall. I
But
mentioned
today, we're not talking about that.
No,
We're
I'm just
talking
saying-
about this issue that has been ongoing.
Okay, I don't like the words that you use or the comment that you use that I don't work with the city, because that's untrue.
Okay?
I do work with the city. I did the wall. You said clean it. I painted it. You said fix it. If there was an accident for the fence, some car hit it. I don't know who hit it. I repaired it. I repaired it. I put scrubbery. I have a lawn guy that comes every month and do that. I clean the opposite side of the street, which is not my property. I clean it and I maintain the scrubbery and grass. I do work with the city. I don't know how you come up to that.
Sir.
I do more than I should do.
Okay, look.
In some aspects, and other aspects I'm failing. But I do the best I
I know,
can.
look, the recycling business is difficult. I'm somewhat familiar with it.
It's very difficult.
I know it is, but, you know, it's a good business to be in. Well, whatever. Now, what do you need to do to comply so that he understands? Because right now, the 5 days, you gotta move quickly. You know, the tag is okay, but it shouldn't be parked there. So if that's the case, you're gonna comply with that in 30 minutes after this hearing is over, okay? It's not gonna, it's not, okay, so what else? All right, so you can get this thing going. Okay.
All right. Okay, what would you like to know again?
Well, can you tell him again so that he knows what he needs to do?
He has to clear Towns Row, which he has done it before, and it's a habitual thing where he clears Towns Row, he puts all his materials back on. Now he has a truck there. Now he's saying it's removed. Not sure if he's gonna have it back. It just has to be clear at all times. It cannot be used for business use.
Okay.
Okay, all right, go ahead, respond. And that's what he needs to do. All right, go ahead.
Okay. In my effort to resolve the issue, I mentioned to you, you have your photos and you see what's going on. You see what's going on there. And I told you, I cannot resolve the issue unless I bring the material out to ship it out. I mentioned to you, you cannot clean a closet out without bringing the material out. And there's no other way I have to do it. I need to bring it out. I'll use more than 3 feet, 4 feet of the town's property that you're saying. My right of way, you saying the town property. I use 4 feet. I use a box or a pallet. That's all I use. 1 row, if I do use it. But I need to bring the material out. I box it, I ship it, I get rid of it. I'm depleting the pile. I must deplete vertically first. Vertical, once I complete vertically, then I can move forward. I can't go forward out starting from the top. So this is what I do every day. I do it every day. You can monitor, you can see the piles are depleting. I have to complete first, then I move forward to the ground. Once I can move forward to the ground, I can resolve a lot of issues. What's going on? I need permission, if that's the procedure, to bring in a large truck or a dumpster to put next to my property, which would be on the right of way, so I can move stuff out a lot faster, bulker. But what I have now is when I move out, you see that's a problem. There's no other way to go but out.
So basically, hearing officer, he's saying that he's going to continue using Towns Row because he has no other options at this time, which this has been, again, ongoing repeat violations years after years, probably since 2011 or probably even before that. So what is your recommendation at this point? Because
So I know when I saw the name A&B Recycling, I think there was a full-blown hearing some years ago, and I think at that time I sat as a hearing officer on it, so it's been going on for a long time. There's
It's not as she said.
no, look, I'm trying to, look, I don't know if you went before the city commission and asked for some type of a variance or special use or something, whether or not the commission would even consider it or grant it. So there's gotta be some other way that you figure out. I don't have jurisdiction in that department, nor do the code officers. The sole role here is to determine whether or not they're violations, okay? I don't know if you can do that. I don't know if it's a possibility. If you could make application, I have no idea if the commission would even consider it, because this is something where they may feel like they can't consider, they cannot consider. So I'm just throwing that out. You're gonna have to find a way to comply with this and not have these violations. Now, when you say that you take the material out and they sit there and you only use, 5 feet or 4 feet of whatever it is, okay, that's still a violation. No,
But it's not, when I do that, it's temporary. It's on a regular basis, but it's temporary.
No, but
Shouldn't be temporary.
Well, I'm just stating the fact.
I know, but
what
you
it is.
can't
I'm
do
just
it.
telling you what it is. And,
I know temporary, how long is it there?
Temporarily, I get a truck. I get enough for the truck, and it goes. And I start the cycle over.
Okay, so why can't you get a truck and put it in the truck immediately rather than put it out there?
If you do that, you put it outside, then she says.
Well, no, but, no, you're taking, from your property, you put it outside in the roadway for whatever, in the,
Box it or palletize it.
okay, but why can't you immediately put it in a truck and not violate?
And still be in violation because I'll be still parked on the right of way. I had a truck there a few weeks ago, say, no, you can't do that. And we was going in the truck.
Okay, so why can't you do all this in your property?
There's not enough ground space in the property.
Okay, I know, but that is not a problem that the city can contend with. Why don't you make room in your
That's
property?
what I try to, that's what I'm doing. That's what I
I know, but you're not doing it, you know,
Sir, that's what I'm doing.
you're trying to do, all right?
I mean, like I said, I have to start from the top and come to the bottom. Then I can go in, because it's the only way to do it.
I know.
I can't start from the bottom and go forward, because then you gotta get the stuff off the top and then go forward.
No, but again, you can't, if he does this in his property, that's okay. It's when he does it outside his properties, when there's a violation, as I understand it.
When okay, look at the pictures, Mr. Hibbler. The fence area. Everything that's within the fence area is his property.
Right.
Everything outside of the fence is town's row.
Right.
So he's right now has all those materials out on town's row,
It
has a
looks
truck.
like- It looks terrible. I
So
know.
that has to be clear. He uses that on a daily basis. His employees are out there cutting cables, operating the business out on town's row. I've gotten reports that there's been accidents, like possible accidents, because sometimes it blocks the view or something like that. So it has to be cleared for safety purposes.
There's none of my material blocking any view, and there's no accidents there.
But it's a
Sir,
possibility.
I'm going by the
You-
reports
where-
that
where
I
you
have
would block.
received. I'm going by the reports I received.
Look, you're gonna have to do this in your property somehow.
I understand what.
Can't do it
I'm trying to
on the
get
town's
done
road,
what
okay?
what she's requesting, what needs to be done. I'm trying to, that's
I
what
know,
I'm
but
doing.
you're gonna have to try harder, because, I mean, I'm looking at the photos. I'm trying to find a way and maybe give you an explanation of what you might be able to do. Okay, I don't, again, I have no idea, but I just don't think that, there is such a thing as a variance or a special exception.
There isn't.
I'm sure there isn't. I just outlined it to try to air out.
Variances are for structures,
Right,
dimensions.
exactly. So you can't really do that.
What did you say?
Structure, dimensions. When you're putting in a structure, and the dimensions and the setbacks, that's where a variance is for.
So your only way to do this is inside your property. You're gonna have to find a way.
Okay, here it mentions here. Okay, obstruction prohibited without specific written municipal approval. That's what I'm requesting.
Well, I can't give it to you. Only the city commission, the town commission can give it to you. And that was where I was headed. And if, in the meantime, before you ever receive it, if you can receive it, and I doubt if you can, but that's not up to me. I'm not a commissioner, I'm just the hearing officer.
You was commissioner before, no?
No, I'm not into, I'm certainly knowledgeable about politics and people running for office, but I never want to hold an office that I'd run for. I'm not into that, okay? Just a hearing officer, all right? So you need to do this inside your property, not outside the property, period. That's the bottom line. Until you get written approval from the city, code enforcement cannot grant that. I cannot grant that. It would be beyond our ability to do that. So you need to see if somebody from the city can give it to you. And if they can't, then you be prepared to pay the $500 a day for, keep coming back for more fines and violations. You don't want to do that. So those are really, I'm only spending the time here. You're the last one on the agenda here, but you've been like a veteran here. So many violations over the years. There's got to be a way. Do it inside or on your own property, not on outside of your property. That's the bottom line. So based on what I've heard, based on the fact that there is substantial competent evidence at this time of violations, the photos, you can't really put it out there and then, pull what, like what might be called, then remove it, then do it again. It's a continuing violation either way. The city is not going to go out there and say, well, you've complied on Thursday morning, but here it is Friday and you're not complying. So I'm gonna concur with the code enforcement officer and find that there's substantial competent evidence of violation here. You have 5 days to stop this nonsense, okay? And I call it nonsense because you know what you can do, what you can't do, so don't do it. Otherwise, if that occurs and continues to occur, it'll be $500 a day thereafter. Do it on your property, not outside, all right? And don't park the van or the truck there, that truck, all right? That's an easy one. The other, find a way, all right? Otherwise, you'll be coming back for assessment of a fine and all the other stuff. And I think you have better things to do than that. Do it inside your property, on your property, not outside. Okay, then do it. Okay. You have to bring a truck inside, do it inside. Don't put it outside. You're going to have to find a way, all right? Anyway, I made my ruling. Appreciate the candor. The city, the code enforcement officer graciously wanted to see what are options. I've outlined them, and you're on your own now, okay? All right, I'll sign the order then.
All right, I don't need it.
Yeah, Nasli is gonna get you a copy of the order.
Good luck to you, sir. Do it. Comply. No more violations, okay? Inside your property, all right? Okay, good luck. No, the case I was referring to, I sat as a hearing officer years ago where it was just atrocious what was going on. And it was like, I think I assessed a gigantic fine and basing it on my recollection. So, I mean, I don't know what else to say, really. God. Anyway, hey, as I say, you have a tough job, so.
Yes.
Now we have the no-shows.
It's too much. We have 16 more cases. Case 4931.
I'm sorry.
Chief Code Officer Jocelyn Ramirez, case 4931, property owner, public storage prop 5, LTD Department PT, Florida 00412. Site address 3080 Pembroke Road, Pembroke Park, Florida. A notice of violation was issued on February 11, 2020. It was posted to the property and sent out by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on October 12, 21, and posted to the property on November 4, 2021. Violations were for security panel ballots, interior renovation of office, portable storage unit with electric installed without building permits. At this current time, the owner has obtained permits for everything except the security panel ballots. And therefore, I'm recommending that it be obtained within 30 days, if not $100 per diem, with a $100 admin fee. And let the record address that the property owner is not present.
Based on the testimony of the evidence of compliance officer, substantial competent evidence to support the city's position, 30 days to comply or $100 per day and $100 cost assessment.
Next case is 5325. Chief Code Enforcement Officer Jocelyn Ramirez, case 5325, property owner IRBA LLC. Site address 3400 Southwest 20th Street, Pembroke Park, Florida. A notice of violation was given on August 19, 2020 by hand and regular mail. Notice formal hearing was sent out by certified mail in September, but was continued till this hearing. Notice of formal hearing with a copy of the notice of violation was sent out on October 28, 2021, and posted to the property on November 4, 2021. The violations were for an 8 ES IntelliNet mesh network communicator that was installed on the fire alarm system without a permit. At this current time, the property owner has not obtained a permit. Therefore, I'm recommending that this be resolved in 15 days, if not $100 per diem with a $100 admin fee.
Based on the testimony of the evidence of code compliance officer, there's substantial competent evidence to support the city's position. They'll have 15 days to comply or $100 per day thereafter. Now, of course, a $100 cost assessment.
And the property owner is not present. Next case is 5437. Chief Code Enforcement Officer Jocelyn Ramirez, case 5437, property owner Amita Development LLC, site address 2350 Southwest 30th Avenue, Pembroke Park, Florida. The notice of violation was given on November 6, 2020 by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on October 8, 2021, and posted to the property on November 4, 2021. The violations were for demolition of drywall and bathroom with shower without permits, installation of new drywall without a permit, prohibited banner sign. At this current time, the banner is still up. The permit was pulled for demolition. However, it is expired, so the property owner will have to start over. Therefore, I'm recommending that this get resolved in 30 days, if not $100 per diem with a $100 admin fee.
Based on the testimony of the evidence code compliance officer, there's substantial competent evidence to support the city's position. They'll have 30 days in which to comply or $100 a day thereafter.
Let the record state that the property owner is not present. Okay. Next case is 5652. Chief Code Enforcement Officer Jocelyn Ramirez, case 5652. Property owner Discount Auto Parts, Inc., care of Advanced Stores Co., Inc., number 9479. Site address 3000 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice of violation was given on March 30, 2021 by regular mail. Notice of formal hearing with a copy of the notice of violation was sent out by certified mail on October 8, 2021, and posted to the property on November 4, 2021. The violations were for graffiti on back end of property in glass. Parking lot requires maintenance, pave and restripe. Obtain plans, permit inspections. Exterior maintenance require pressure wash common areas and walls. Exterior maintenance required, repair facades, drains, and rails. Installation of electrical cameras and light fixtures without a permit. Obtain plans, permit inspections. Permanent window signs are prohibited. But I'm gonna redact that item on the violation since the zoning planner and I had discussed, and permanent window signs are allowed, but based on the town planner's discretion. There's dead vegetation that has to be replaced. And then also the removal of trash and debris and miscellaneous items. at this current time, the property owner has only complied with the removal of the graffiti on back end of property and glass. Therefore, I'm recommending that this gets resolved within 45 days, if not, $100.50 per diem and $100 admin fee.
Then,
45 days?
right, 45 and $100.
150.
Oh, 150. Okay, there wasn't enough room here. I'm just gonna do it right here, 150.
Okay.
Order. That's fine. I got it. It works.
Okay.
Perfect place here. She'll pay at the end. Based on the testimony you have as a compliance officer, there's substantial competent evidence to support state's position. They have 45 days which to comply, or $150 per day until there's compliance and a $100 cost assessment.
Let the record state the property owner is absent.
Yeah, right. What I did is that. It works out. Is that okay? Yeah, that's all right.
Next case is 6060. I'm only giving a testimony regarding the property so we can adjudicate it.
Great.
Is there any particular documentation that we need to adjudicate it?
No, no.
Okay.
You can just testify, and that's good enough. The respondents have been noticed, they're not here. There has to be something in the record, and your testimony is enough.
Chief Code Enforcement Officer Jocelyn Ramirez, case 6060, property owner VNA Miami LLC, tenant Coast to Coast doing business as Boost Mobile, property address 4400 West Hallandale Beach Boulevard, Pembroke Park, Florida. Notice of violation was given on July 26, 2021 by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on October 28, 21 and posted to the property on November 4, 21. The violations were for prohibited flag signs and prohibited window signs. So, the property owner, the tenant, continuously puts out banner signs. We have pictures that depict the violations from July 19, 2021. April 8, 2021. And October 25, 2021. So the reason why I wanted to adjudicate it is because, as you can see, there's multiple times that they continuously bring out the banner. And in the future, if they do it again, I will like to impose a fine. But the property is in compliance.
So the order, no per diem.
You have an order there?
Yeah, the order is a standard order, and this is DNA Miami LLC, DBA Coast to Coast, DBA Boost Mobile. So she'll comply here. So do you want to do the order over, or do you want me to somehow write it up?
Yeah. Just write it up, right?
Yeah, okay, a new one, because this says they have a certain amount of days to comply.
Right.
And you're not, you just want it for a repeat violation in the future.
Right.
I would think, okay. Based on the,
Maybe it's a different order to adjudicate?
yeah, you probably gonna wanna, do you know, have you done one of those?
No, she
Where is-
hasn't done it.
Okay,
But I can do it.
Yeah, we can do it.
okay, why don't we, All right,
We can discuss it after.
okay, yeah, and then that way, you'll do it.
You can state it for the record, and then
Yeah.
we'll draft it.
Right, I'll say that but they've complied, but they hadn't complied, they complied before the hearing, but not before the violation occurred. Something like that, okay? Comply by hearing date, but not cited, so it's no per diem. I'll find that there's substantial competent evidence that support the city's position that there is a violation, but not at the hearing date, but there was a violation. Therefore, there's no per diem. There is $100 cost assessment. No days for compliance because they have complied. Correct?
Yes.
Okay, all right.
And you already stated that no one was present, right?
Right, and no one was present, of course, yeah. Go ahead and call the next one, we'll get it done.
Okay. Next case is 6110. Chief Code Enforcement Officer Jocelyn Ramirez, case 6110, property owner Ali Verdi Family LP, tenant Checkers, property address 4000 West Allendale Beach Boulevard, Pembroke Park, Florida. Notice violation was given on July 30, 2021 by regular mail. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on October 28, 21 and posted to the property on November 4, 2021. Violations were for prohibited snipe signs and prohibited banner signs. At this current time, the property is not in compliance. Therefore, I'm recommending that this gets resolved within 5 days, if not $100 per diem and $100 admin fee.
Based on, you said $100, what's the per
Yes,
diem?
$100 per diem.
Based on testimony you have as a compliance officer, there's substantial competent evidence to support the city's position. They have to comply within 5 days today, or $100 per diem thereafter, and $100 administrative fee cost.
Next case is 6278. Chief Code Enforcement Officer Jocelyn Ramirez, case 6278, property owner Canal Street LLC, site address 3744 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice of violation was given on September 13, 2021 by regular mail. Notice of formal hearing with a copy of the notice of violation was sent out by certified mail on November 1st, 2021 and posted to the property on November 4th, 2021. The violations are for a damaged ceiling. Kitchen ceiling is leaking water. Obtain plans, permit, and inspections for repair. At this current time, the property owner is not in compliance as of my last inspection. on November 3rd, 2021. I'm recommending that this gets resolved within 15 days, if not $100 per diem with a $100 admin fee.
Based on the testimony of the code compliance officer, there's substantial competent evidence to support city's position. They'll have 15 days from today to comply, or $100 per day thereafter if they don't comply, and a $100 cost assessment fine will also be implemented or enforced.
Let the record state that no one is present.
No, that's okay. I have a strange way of strike that, right? You strike that. And then you continue on violating the town, but comply by the hearing date.
Last case.
No big deal. Thank
I
you.
will do it right now.
That prior case I was going over to, that there was compliance by the hearing date, but they violated, no per diem, but the $100 cost assessment.
Okay.
That's okay, yeah, all right.
All right. In the future, when I have a case like that, I can start the per diem fines from the day of the compliance date on the violation.
With a repeat violation, you can start it on the date you cite,
On the day I cite, okay.
but that's not what you're referring to. On a-
Because let's say if a repeat violation, I cite it on October 5th, 2021, but I give them 10 days to comply. So the fine will start to accrue from October 15th?
Yeah, from the earliest date, you can go back to the date of violation. You don't really need to give them 10 days. In fact, you don't even need to give them 10 days. You cite them that there's a violation, and then you bring it to the code enforcement hearing. Otherwise, they might later argue, well, you were supposed to give me 10 extra days. You don't need to do that. That's, the statute specifically says that it can relate back to the date of violation rather than the date of the hearing.
But that's just for repeats.
Yes, exactly, just for repeats. So, and sometimes, my experience is the city will prefer to still give them some time. That's your call to be nice, but you don't have to be nice. You can go back to the date of violation as long as it's a repeat violation. And it continues to accrue, because by the time you have a code enforcement hearing, it may be 30 or 40 days until that happens. And it continues to accrue from the date of the violation.
All right. Next case is 4863. Chief Code Enforcement Officer Jocelyn Ramirez, case 4863, property owner Cap 5000 LLC, property address 2601 South Park Road, Pembroke Park, Florida. I'd like to state for the record that this is a case that James Tisdale had written back on October 3rd, 2013. The file has just been sitting there, but there's actually fines that accrued and have not been paid. So I'm confirming a fine today.
Okay, I'll go ahead and confirm the fine, which is $900. They're being compliance, and I just signed the order.
Right. I'd like to state the breakdown of the fines. The fine accrued for 11 days from November 8, 2013 to November 19, 2013 at a per diem of $50 per day, which accrued $550. There was a standard fine of $250 and an administration fee of $100 that accrued to $900. And that concludes all my cases.
Next. There you go.
Officer Teresa Malcolm from Pembroke Park, Florida. Case 5623. Property site address is 5455 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owners are Robert and Consuelo Rudas, REVR Rudas.
5623.
23, yes. Okay, I'll give it to you in a second. I'll give it to you after. Sorry, Robert and Consuelo Rudas, REVTR Rudas, RJ and Consuelo as trustees. Original notice of violation was on March 18, 2021 by regular mail. Affidavit of service posted to property was on November 3rd, 2021. Certified mail was the formal hearing notice with a copy of the NOV on October 22nd, 2021. Original notice of violation was for the fence installed without a permit. Since I had no access to the AC, since it's within the fence, it's also to verify if a permit was pulled for the AC or not. My recommendation is to give those owners 60 days with a $50 per diem after that.
We're waiting the order. No big deal.
I'll give it to you at the end prior of us leaving.
This is Revez, REVEZ. Spelling of the name.
Well, it's a lot.
You'll let me know.
Yes.
This is the one.
Their name is extensive.
Mr. and Miss X. How about that? X, Y, and Z. Whatever. Okay, based on the testimony you have as a compliance officer, there's substantial competent evidence to support the city's position. They'll have 60 days in which to comply, or $50 a day thereafter.
Five 5623. 5629 is next. Property site address is 5453 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owner is Marianne Simon. Notice of violation was written on March 18, 2021 via regular mail. Formal hearing was certified mail on October 22nd, 2021, posted to the property on November 3rd, 2021. Notice of violation was for new installation of an AC. And also to remove the prohibited outside stored items. So my recommendation, since no one is 60 days with the $50 per diem.
You said $50? $50
Yes.
Okay.
Yes, I'm sorry.
No fault of your own, sometimes the microphone phases out at the end there. That's okay. Based on the testimony evidence of the code compliance officer, the substantial competent evidence to support the city's position, they'll have 60 days in which to comply, or $50 a day thereafter. Thank you.
5644. Property site address is 5433 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owners is Ivernes, I'm not sure how to say the name, Cervantes.
Close enough.
What she
You're
said.
going to have to turn the pronunciation over to your colleague there, and so will I. Okay, there you go.
Original notice of violation was on March 22nd, 2021. Notice of formal hearing was certified mail on October 22nd, 2021. Posted to the property on November 3rd, 2021. An original notice of violation was for the new AC that was installed without permits, as well as the AC slab. Camera system was installed without permits to repair the patio slab and also to remove the prohibited outdoor stored items. My recommendation, since one is here today, is 60 days with $100 per diem.
60 days, within 60 days, or $100 per diem. This is Inversiones, Sorrento. Okay. Based on the testimony of the compliance officer, substantial competent evidence supports city's position, they'll have 60 days in which to comply, or $100 per diem thereafter. Going back to the V&A Miami LLC 6060, what I did, the final order will say, it is the order of the special magistrate that based on the foregoing, the respondents violated the town of Pembroke Park Code Ordinance sections, but complied by the hearing date held on 17th day of November 2021. In addition to the fines assessed, which there aren't any, a mandatory administrative fee, $100 is assessed, and I signed that. All right. Perfect. Yeah. Good. Good enough.
Five, 6, 7, 7. Property site address is 5407 Southwest 41st Street in Pembroke Park, Florida, 33023. Property owner is Miguel Perez. Original notice of violation was written on March 23rd, 2021. Posted to the, notice of formal hearing was certified mail on October 22nd, 2021. Posted to the property on November 3rd, 2021. Original notice of violation was for an AC that was changed without permits. Also to remove the prohibited stored items from the backyard with the double permit fee assessed. My recommendation is to give the owner 60 days with a $50 per diem after that.
Based on the testimony of the compliance officer, there's substantial competent evidence to support city's position. They'll have 60 days in which to comply, or $50 per day thereafter, and a $100 cost assessment.
Six, 164. Property site address is 4100 West Hondo Beach Boulevard, Pembroke Park, Florida, 33023. Property owner is Cole FD Portfolio LLC, in care of Family Dollar Stores 26608. Original notice of violation was written in August 24th, 2021. Certified mail was the notice of formal hearing on October 25th, 2021, posted to the property on November 3rd, 2021. The original notice of violation was for the graffiti on the ice cooler. The exterior walls have dirt buildup, rust, vines, and damage. and damage. You laughing at me?
She needs the order, that's okay.
Oh.
It's okay. Everything's cool.
I'm sorry, I'm sleepy too.
Don't worry about it. Look, this can get really tedious and boring, obviously, so relax. Okay, don't worry about it. Go ahead.
The facades needed to be repaired to trim the overgrown vegetation, including the trees along the property line. The parking lots are faded, unleveled, rusted with multiple cracks and broken parking stumps and curbs. Also to remove the excess trash and debris from the property and maintain it. The property has missing and damaged parking signs, including the ADA signs. They're rusted, damaged, or twisted. To remove all the window signs from the windows. Between the adjoining neighboring property to remove all the trash and debris inside that chain link fence area with the weeds and overgrown vegetation. The building and walls need to be painted and maintained. Vinyl siding at the side of the property has damages and needs replacement, and also the double permit fee that would be assessed. This is their fourth offense for Family Dollar. Case 641 was the first offense, case 4306 was the second offense, and case 5006 was the third offense. So my recommendation is to give them 15 days to become into compliance, if not a $500 per diem after that.
Based on testimony of the compliance officer, there's substantial competent evidence to support C's position. Give them 15 days to comply or $500 per diem, thereafter an $100 cost assessment. Anyway, that's what I was suggesting. And you can either go back retroactively, you don't have to if it's a repeat violation, or you can give them a minimum amount of days and go forward, and maybe they'll get their act together one day and comply. Usually, they don't go back to the retroactive date, but you can do that. But you did, this is fair, this is fine.
This is fair for them.
Exactly.
They started complying, but.
Exactly, but there's a repeat violation many times over, so, but that's fair. That's good of you. Okay, and I just signed off. It's 15 days and $500 per diem for each day thereafter. Good. And a $100 cost assessment.
Case 6288. Property site address is 4790 West Hollandale Beach Boulevard, Pembroke Park, Florida, 33023. Property owner is Hanlex Properties LLC, also known as Dollar General. Original notice of violation was written on September 16, 2021. Notice of formal hearing was certified mail on October 22nd, 2021, posted to the property on November 3rd, 2021. The original notice of violation was for property, the property walls need to be pressure washed and painted. Also including the concrete walls alongside the property lines at the back of the store by the dumpsters and the walls at the front and the back of Southwest 31st Drive, and also to remove the graffiti tags on that back wall. Racking shelves are loose and scattered alongside the back of the store with cardboard boxes and excess debris. Racking needs to be in a designated area to be stored due to us being currently in hurricane season. 3, missing hedges in the gap of the front of the concrete wall on Southwest 31st Drive to replace the hedges in that gap. Concrete columns at the concrete walls are damaged with the mesh exposed, which requires a permit for concrete restoration. The dumpster provided by Waste Management is damaged and needs a replacement dumpster. Remove all the excess crates from inside the dumpster enclosure since they're loose and not tied down to anything. Property has a trash nuisance which needs to be maintained, including trash and debris in the landscaping throughout the property lines, and town swale, which is prohibited, to illegal dumping, trash in the shut-off valve box at the front of the property's entrance door, the parking lot area. Well, parking lot has oil stains and dirt buildup with cracks in the concrete curbs and damage to the parking lot boulders, which needs repairs or replacements. Remove the illegal donation box completely from the property. Property has damaged and fallen right turn only sign, which needs to be fixed and reinstalled. At the entrance or exit pathway on Southwest 48th Avenue, concrete blocks by the field drain needs to be pressure washed from all dirt buildup. Remove all growing weeds in the black screens of the side of the building. Partially damaged panel needs repair on the top of the trim of the building. Damaged mansard needs repair. Needs a permit for repairs and replacement. To cut and trim the hedges, the trees, and remove all the weeds on the black chain link fence alongside the property line and keep it maintained. Entrance door and sidewalk or pathway to the store needs to be pressure washed or use a treatment to remove the rust from the area. And also, front of the property has electrical outlets which are currently missing the covers for them. To obtain a permit for a safety check with the electrical inspector. Since no one is here today, my recommendation thanks. So it was like a hit and a miss with Dollar General. They complied by removing some of the trash as much as they could, but it's an ongoing thing where it's a daily thing where there's trash and then there's not trash and then there's trash. So it's like a back and forth with it. What they also complied with was, I don't think it's in compliance. They went ahead and they repaired the mansard, but they didn't get a permit for it, the mansard. Also, they went ahead and they got a replacement dumpster from Waste Management. And that's all they comply with at this time. Oh, I'm sorry. I thought we removed it. Okay, and the donation box was removed from the property. Since this is their third offense, thank you, I'm looking for it. Referring to case 4766 is the first offense. Case 6147 is the second offense. My recommendation is to give them 15 days to come into compliance, and after that, a $500 per diem.
Based on the testimony evidence of the code compliance officer, substantial competent evidence to support the city's position, they'll have 15 days in which to comply, or $500 per day thereafter.
Fines. Case 4447. Property site address is 65 West Lake Drive in Pembroke Park, Florida, 33009. Property owner is Michael Donias. We're confirming the fine today for $1,200. the breakdown of the fines. A final order was entered in the record on July 20th, 2021. $100 admin fee, which still wasn't paid as of yet. The fines accrued for 30 days from October 18, 2021 to November 17, 2021, with the fines totaling $1,500. So they have a balance that we're confirming today for $1,600.
I'll go ahead and confirm the fine at $1,600. Yes.
Case 5699. Property site address is 1820 Southwest 30th Avenue in Pembroke Park, Florida, 33009. Property owner is Rollins Continental Inc., also known as Orkins. Breakdown, sorry. So a final order was entered into the record on July 20th, 2021 with a $100 admin fee, which recently was paid. The fines accrued for 60 days from September 18, 2021 to today's date, November 17, 2021. We're confirming the fines today for $3,000.
Based on the testimony of the compliance officer, I'm going to confirm the fine for $3,000.
Case number 5840. Property site address is 5100 Southwest 41st Street in Pembroke Park, Florida, 33023, Unit 219. Property owner is Paradigma Corp. Bear with me. A final order was entered into the record on July 20th, 2021, with the admin fee of $100. The fines accrued for 30 days from October 18, 2021 till today's date, November 17, 2021, for $1,500. So we're confirming the fine today for $1,600.
Will do. Based on testimony of the compliance officer, I'm going to confirm the fine for $1,600.
Ends my cases.
There's only one order that you're going to get me.
Yes, I'm gonna get that for you right
That's
now.
okay. I just don't want you to forget. Otherwise, you'd have to email it, scan it, email it. I'd sign it and get it to you.
We're gonna get it to you right now.
I know. That's okay. I've done it the other way too. So whatever works. That's okay.
What happened?
Please. Okay. 5623. I'm gonna get it.
We finished?
Yes.
After the hearing officer calls adjournment?
I can adjourn now, and then or I can wait till she comes back.
Okay.
Order.
All right, well, we'll wait till she comes back.
Okay, so whatever. It's no big
That
deal.
way it's recorded.
I can put complete, no? Okay.
It's a long one today, so.
Starting to turn it off.
But the other, that's when it's off.
Still recording, but it doesn't matter.
I need to turn on that one. Okay.
What I'm saying is it doesn't interfere.
But I don't need to put any picture or agenda again in the TV, so. Mm-hmm.
Wait.
Yeah. Yeah. For me, no.
Yeah, I don't know why. Of course.
And Jeffrey not asking for text and nothing. What for lunch, guy?
I think
For
so.
me,
Yeah.
no.
I think it's enough for most.
Tostada con jamón, que fue lo que trae.
Or,
The word to me.
yeah, but
Solo
that'll
jamón.
be, so mom and dad will be busy enough and
No, no problem.
pay enough, I'm sure, so.
Pasó con el queso.
Too much money.
¿Todavía está
Yeah.
ahí? ¿Lo podemos comer? Yesterday? But I think we can eat it today.
Okay.
Cheese.
Sí.
Would you like some expired cheese? They expired.
Hey, doesn't matter.
I don't think it matters, so. That's okay. No, that's cool. That's all right. This is the one. Yeah.
Yes.
Roberto
That's
and
why I told you it's a
Consuelo.
lot. It's-
Ruta, revocable trust, good grief. Anyway, case number 5623. Based on the testimony of the evidence compliance officer, this is heard before. There's substantial competent evidence to support the city's position, and they'll have 60 days in which to comply, or $50 per day thereafter. Excellent. Thank you. All right. Good job. Thank you, everyone. Good job as always. So, thank you. All right, I'll go ahead and adjourn these hearings. It's 2 o'clock, 2 p.m. Everyone stay safe.